special committee to investigate charges prior to any plenary vote. In conclusion, His Excellency Gachagua drew inspiration from the Filipino Supreme Court in Sara Duterte versus House of Representatives. We have given citation to reiterate that impeachment processes remain strictly subject to the Bill of Rights to check grave abuses of discretion. Consequently, they urge the court to utilize its discretion as established in Manyara and two others versus Attorney General to award damages for the constitutional violations to vindicate His Excellency Gachagua's right and deter future legislative infringements.
I will proceed from the second petitioner's case, that is Thomas Kimoto Maingi. Thomas Kimoto Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024 before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before returning in May 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachagua portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. He asserted that the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and speech made on the 26th of June 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submission. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petitions, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion as and in public interest, Her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that the public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and unconstitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution and challenged the constitutionality of Standing Order number 64, 2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 145, Sub-Article 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional 2/3 gender principle under Articles 27, 81B, 102, 161 of the Constitution, and was therefore incapable of lawfully entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024, as ordered by this Honorable Court regarding the special motion, were in disregard of the court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in their in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145, 3B of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petition respondents outside the select committee of Senate under Article 145, Sub-Article 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 27, 81B, 102, 61 of the Constitution on the 2/3 gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first stated party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, which she further orally highlighted in court. She identified the following issues for determination. 1. Whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B. Whether the yes-no template deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3. Whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4. Whether the Senate violated Article 145(3)(b) by failing to appoint a special committee of 11 members. 5. Whether Standing Order 64(2) prescribing a 12-day impeachment timeline is constitutional. 6. Whether the impeachment process violated Article 50 on fair hearing protections. And 7. Whether the impeachment proceedings were conducted by impartial officers as required by Article 50, sub-Article 1 of the Constitution. Honorable Maina submitted that on the 3rd of October 2024. Honorable Justice Mongo, a judge of the High Court sitting at Kariguya, ordered inter alia that public participation be undertaken at the constituency levels so as to accord the public an opportunity to engage and offer their representations. That these orders were duly served and were never appealed, stayed, varied or reviewed, and as such, they remain binding on the respondents, absolutely. Speaking to the obligation to obey court orders, Honorable Maina submitted that such obedience is foundational to the rule of law as was held in Law Society of Kenya and 3 others versus Inspector General of Police and 4 others reported in 2024 KEHC KLR. She submitted that this obligation extended even to cases where the person affected by an order believes it to be irregular or void, as was held in Refrigeration and Kitchen Utensils Limited versus Gulab Chand Popatlal Shah and others, the civil application number Nairobi 1339 of 1990. She further submitted that proper compliance required reasonable notice and not the same day or the next day notice. Physical accessibility at constituency level with open, identifiable venues in each of the 290 constituencies, facilitation of engagement, including civic sensitization, information, language diversity, disability access, and hearings as the primary mode, including oral and interactive engagement. Learned Counsel further submitted that the orders were not obeyed and only 200,000 participants countrywide who made up to 0.4% of the Kenyan population turned up for the exercise. Council decried the one-day notice published on a Saturday whose contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no hearings were ever organized, no facilitation was provided, and that CDF offices were closed and the MPs absent. Honorable Maina submitted that she became aware of the purported exercise only past midday and that none of her counterparts within the Kirinyaga County were aware of the exercise. She further submitted that even the citizens who visited the constituency venues found them locked and no officials or staff were in sight. It was submitted that the National Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64(2), which provided for 7 days deadline. They chose the latter, which Honorable Maina describes as contempt, dressed as obedience. That a legislative outcome obtained in defiance of a binding court order cannot stand in a constitutional democracy governed by the rule of law as discussed by Lord Denning in McFoy versus United States Company Limited, United Africa Company Limited, reported in 1961, 3 All England Reports 1169, where the learned judge held that, I quote, if an act is void, then it is in law nullity. You cannot put something on it and expect it to stay there. It will collapse, end of quote. Honorable Maina also took issue with the yes and no template as constitutional fraud, as the National Assembly deployed a standardized template reducing 7 complex constitutional allegations into binary tick box questions. That citizens were asked whether they supported impeachment on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachagua's response, relying on the Supreme Court in British American Tobacco BAT versus Cabinet Secretary for Health 2019, which we'll hereinafter be referring to as the BAT case. She articulated attributes of meaningful participation to include clarity of the subject matter for the public to understand, structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence outcomes, and inclusive and effective representation. She also listed integrity and transparency of the process and capacity to engage on the part of public, including sensitization of the subject matter. Honorable Maina admitted that the digital-only, English-only mechanism systematically excluded rural residents, the elderly, persons with disabilities, the non-English speakers, and the non-English speakers. She stated that there were no physical venues for explaining the template or receiving oral views, that were only in 10, that there were only 10 pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained conflated responses from 4th and 5th October without distinction, obscuring the impact of the court's orders. She identified that the template was not a procedural imperfection, but an endorsement mechanism designed to manufacture numerical support for a predetermined outcome, and is therefore constitutionally void. It was her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business, that the Senate is not a subordinate appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where she stated that the Senate's role in impeachment is determinative under Article 145(7), as it performs a quasi-judicial function of the highest constitutional order. She held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders. That the Senate was aware of these defects as they were documented, litigated, and judicially acknowledged. Counsel submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025 Kenyalo reports, this court held that Senate must satisfy itself that public participation was adequate, and satisfaction requires inquiry, assessment, and independent judgment, but the Senate undertook none. That the Senate conducted no public participation whatsoever, as no notices were issued, no invitations were extended, no hearings were conducted, and no submissions were received, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145, Subarticle 3B of the Constitution provides that the Senate may appoint a special committee comprising 11 members of its members to investigate the matter. On that, she submitted that the word may was a grant of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which include a special committee. She further stated that under Article 145, Sub-Article 6, it provides that the Senate jurisdiction to vote is triggered only if a special committee reports that allegations have been substantiated, and absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving, interrogating, and testing evidence, producing a reasoned report, and insulating investigation from the volatility of plenary politics. That Article 145, Sub-Article 5 of the Constitution, guaranteed the Deputy President the right to appear and be represented before the special committee, and by bypassing the committee, the Senate extinguished an entire constitutional hearing stage guaranteed to the Deputy President, thus violating the non-derogable right to a fair hearing. Learned Counsel submitted that standing orders confirmed this distinction as Standing Order 79 on the Deputy President impeachment provided for a special committee, but no alternative. That Standing Order 80 of the Governor's impeachment procedure, impeachment expressly provides two alternatives, that is a special committee or a plenary investigation. It was then posited that where the drafters intended to permit plenary investigation, they could have said so, and that the omission of the Deputy President must be respected. Learned Counsel drew parallels to Section 33(3)(b) of the County Governments Act, which provides that the Senate may appoint a special committee in governor impeachments, and that the courts, including Wambora, have held that this confers discretion, and the Senate has lawfully proceeded in plenary. That those decisions underscore the opposite point, that where law expressly provides alternatives, discretion exists, but where the Constitution provides only one investigative pathway, the discretion does not extend to inventing another. She submitted that by proceeding to plenary determination without appointing a special committee, the Senate acted without jurisdiction, bypassed a constitutionally mandated investigative stage, and extinguished a guaranteed hearing right. She also submitted that Senate had collapsed constitutionally distinct phases into a single political exercise, and the impeachment proceedings were therefore unconstitutional, null, and void ab initio. It was a further submission that Standing Order 64(2) lay at the heart of the constitutional infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. Council invoked Article 2(4) of the Constitution, which provides that any law that is inconsistent with the Constitution is void to the extent of the inconsistency. She placed reliance on Orange Democratic Movement Party versus Speaker of the National Assembly, reported in 2024, where this court affirmed that standing orders cannot override the Constitution nor substitute the constitutional requirements of public participation as expounded by the courts. In that light, Parliament's invocation of good faith was faulted, it being argued that Standing Order 64(2) structurally precluded constitutional compliance. She submitted that where a standing order made adherence to constitutional obligations impossible, such a standing order is itself unconstitutional. It was further submitted that Standing Order 64(2) embodied a deliberate parliamentary choice to prioritize political expediency over constitutional safeguards. By prescribing rigid timelines, it ensured that once an impeachment motion gained initial traction, the process would be driven to conclusion before public sentiment could evolve. before courts could intervene meaningfully or before the affected office holder could mount an effective defense. Counsel argued that this was precisely what the Constitution sought to prevent, since impeachment is a mere vote of no confidence, but a quasi-judicial constitutional process carrying grave consequences. On that basis, it was argued that this court should declare Order 64 now timelines incompatible with constitutional requirements, and that any impeachment conducted under its terms is tainted with illegality from inception. On the question of whether His Excellency Gachagua was accorded a fair hearing, Honorable Maina submitted that he was hospitalized with chest pains on the eve of the Senate proceedings, despite medical evidence incapacity. The Senate proceeded, breaching the most basic tenet of the fair hearing rule, audi alteram partem, meaning no person shall be condemned unheard. Counsel further argued that the 12 days between service of the motion and the National Assembly vote were constitutionally inadequate, given that Article 50, Sub-Article 2B guaranteed the right to have sufficient time and facilities to prepare defense. His Excellency Gachagua, it was emphasized, faced 11 complex constitutional allegations, including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Swecho case, which we referred above, impeachment proceedings attract the where a fair hearing is denied, the process collapses. On the issue of bias and premeditation, learned counsel submitted that both speakers of parliament, as presiding officers of the impeachment, should be required to maintain impartiality, but acted contrary, argued that they assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than neutral arbiters. In particular, Speaker Moses Wetangula of the National Assembly was said to have participated in public statements endorsing the impeachment before presiding over the proceedings. Counsel emphasized that the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility of bias, and submitted that the speaker's public statements and advocacy for impeachment satisfy this threshold. Where the presiding officer is biased, she argued, the totally unfair, and the failure of the speakers to rescue themselves irredeemably tainted the process. For the above reasons, Honorable Maina urged the court to grant the relief sought in her petition. Next is the 4th to 8th petitioners' cases. The 4th to 8th petitioners in the consolidated petitions, that is Honorable David Munyi Madenge, Peter Gechobi Kamoto, Grace Modoni Mwangi, Clement Muchiri Muriuki, and Edwin Munene Kariku jointly filed a petition dated 18th of October 2024 before the High Court of Kenya at Kerugoya. They described themselves as residents and leaders drawn from various constituencies within Kirinyaga County, and stated that they instituted the petition both in their personal capacities on behalf of their residents of their respective constituencies and in the wider public interest. The petitioners herein challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua, together with the subsequent nomination and approval process relating to Honorable Kindiki, relating to His Excellency Kindiki as Deputy President nominee. They contended that the public participation process conducted by the National Assembly on the 4th and 5th October was illusory, inaccessible, and unconstitutional. In particular, they pointed to the issuance of short and ineffective notices, lack of sensitization, inaccessible venues, absence of parliamentary officials at designated constituency sites, closure of the Kirinyaga Central CDF Hall, and the overall failure by both National Assembly and the Senate to facilitate meaningful participation as required under Articles 10 and 118 of the Constitution. The petitioners further asserted that Senate unlawfully conducted impeachment proceedings in plenary instead of through a special committee under Article 145(3)(b) of the Constitution, and that the rash timelines imposed under Standing Order 64(2) of the National Assembly standing orders were unconstitutional as they curtailed effective public participation and the hearing and the fair hearing rights. They also alleged that the Senate violated His Excellency Gachagua's constitutional allegations. They also alleged that the Senate violated His Excellency Gachagua's non-derogable rights under Article 25(c) and 50 of the Constitution by refusing to adjourn proceedings on the 17th of October 2024, despite his hospitalization and medical emergency, thereby denying him an adequate opportunity to be heard. In addition, the petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contending that the process contravened Sections 3 and 6 of the Public Appointments Parliamentary Approval Act, Chapter 7 of the Laws of Kenya, for want of adequate notice and public participation. The petitioners then sought the following prayers. A declaration that the appointment of Professor Kithure Kindiki, the second interested party herein, as Deputy President of the Republic of Kenya is invalid, null and void. B, a declaration that the National Assembly as a distinct organ is required to undertake its own distinct, proper, effective and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to the impeachment of a president or a deputy president. C, a declaration that the Senate as a distinct organ was required to undertake on its own distinct, proper, effective, and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to a resolution from the National Assembly to impeach a president or a deputy president. D, a declaration that the public participation as scheduled by the first and the second respondent on 4th of October regarding the special motion was not a proper and effective and meaningful public participation as envisaged in Articles 10 and 18 of the Constitution. E, a declaration that the extended public participation scheduled by the first and second respondents on 5th October 2024 was in disregard of the court orders issued by the High Court sitting at Kerugoya in constitutional petition number E014 of 2024, Honorable Jane Jerry Maina versus the National Assembly and 4 others, and was not a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. F, a declaration that the impeachment process as against the first interested party was undertaken by the first and second respondents in view of the impugned, improper, ineffective, and meaningful public participation held on the 4th and 5th October was unconstitutional and therefore void. G, a declaration that the failure by the third and the fourth respondents to undertake any public participation at all in regard to the impeachment proceedings in the Senate as against the first interested party renders the whole Senate impeachment process unlawful and void. H, an order of certiorari to bring up into this honorable court and quash the decision and or the resolution by the first and the third respondents made on the 8th of October 2024 and 17th of October 2024, respectively, resolving to remove the first interested party as deputy president of Kenya by impeachment. I, a declaration that there exists no vacancy in the office of the deputy president, allowing the fifth respondent to nominate anyone to fill such vacancy, and that any such nomination is unlawful and void. J, any other order or orders that this court shall deem just and expedient in the circumstances. K, cost of the suit. Next is the 4th to 8th petitioners' submissions. In their submissions led by counsel, Mr. Evans Ogada, together with Mr. George Sakimpa, the 4th to 8th petitioners identified the following issues for court's determination. A, whether the impeachment process complied with Articles 10, 118, 145, and 150 of the Constitution, whether the public participation conducted by the National Assembly and the Senate met the constitutional threshold of being meaningful, adequate, effective, and lawful. C, whether a standing order 64-2 of the National Assembly is unconstitutional for imposing rigid timelines that undermine constitutional safeguards. And D, whether Article 145 and applicable standing orders require that investigation into impeachment charges be conducted exclusively by a special committee of the Senate, not by the Senate sitting in plenary. They submitted that Article 10 binds all state organs, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance. That the impeachment process was conducted with severe haste and limited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision in Speaker of the Senate versus AG and another reported in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct business openly and facilitate public participation, and that this was not a formality, but a substantive constitutional obligation. They contended that the National Assembly gave the public less than 48 hours to consider complex, voluminous impeachment charges, which is a manifestly inadequate time frame, that no explanatory notes or responses from the deputy president were provided, and that in some counties, like Kirinyaga, designated venues were inaccessible. They further asserted that the Senate conducted no independent public participation at all, as it relied on the National Assembly's deficient exercise, which cannot cure the constitutional breach. And they relied on authorities in Law Society of Kenya versus National Assembly of Kenya, 3 others, reported in 2025 KLR, National Assembly and another versus Okoit and 55 others, Civil Appeal number E003 of 2023, consolidated with others. This is the decision of the Court of Appeal. They also relied on the decision of Doctors for Life and and the decision in Legal Advice Center, and 2 others versus County Government of Mombasa. On the unconstitutionality of the National Assembly Standing Order 64-2, Learned Counsel argued that the provision imposes rigid and unreasonable timeline that make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights, and Article 2.4 voids any law inconsistent with the Constitution. The petitioners urge the court to declare Standing Order number 64-2 unconstitutional. As the matter in which the Senate proceedings were to be undertaken, Counsel submitted that Article 145.3 provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive and between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, sub-article 4, sub-article 5, and sub-article 6 refer exclusively to the special committee, and that there is no mention of plenary investigation or under expresso inius est exclusio ulterius, that excluded all other modes of investigation. The petitioners submitted further that the special committee ensued separation of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary fused investigation, hearing, and the judgment into a single political process, violating the hierarchical and sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and 3 others was the Speaker of the Senate. This is the Court of Appeal decision, where the Court of Appeal held that the removal of a governor, which mirrors Article 145, is hierarchical and sequential in nature. Counsel argued that the Deputy President was denied a constitutionally prescribed procedural safeguard available to state officers facing removal, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50, sub-article 1 guarantees the right to a fair hearing, which is expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the Deputy President was hospitalized and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Counsel emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachagua versus Speaker of the National Assembly and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Counsel concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. A declaration that Standing Order 64-2 is unconstitutional. A declaration that the Senate unlawfully bypassed the special committee and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria mtaani na Shedrack Komboy, organization, filed a petition dated 18th of October 2024 together with a supporting affidavit sworn by Dr. Moy, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting constitutional rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachagua from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Ndiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachagua's constitutional rights under Article 25C, 47, 50, and 45, sub-article 5 of the Constitution, that the Senate unreasonably declined to adjourn the impeachment proceeding and had given an opportunity to personally defend himself against the impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachagua, while allowing the proceedings to continue on the basis of asserted that although the Constitution contemplated an expeditious impeachment process, the constitutional timelines could not override His Excellency Gachagua's non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria mtaani na Shedrack Komboy further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Ndiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated that the Senate proceeded with expanded proceedings, leading to his removal from office in his absence, which violated Article 25C, 51, 47, and 145. The relied on the Supreme Court decision in the year of orders, reported in 2015, which affirmed that fair which held that rules of presidential justice applied to all bodies exercising judicial, quasi-judicial, or administrative duties. It submitted that the Senate has no prescribed time limitation for completing different proceedings, and the rushing was unjustified. It was the organization's submissions that Article 148(1) requires that a person nominated as Deputy President must satisfy the requirements of Article 137 and 137(1)(b), or 137, and that Article 137(1)(b) provides that a person is not eligible for nomination as President and by extension Deputy President if they hold any other state office, and that Article 260 defines state officer to include a Cabinet Secretary. It submitted that at the time of the nomination and parliamentary approval on 18th of October 2024, His Excellency Kindiki was serving as the Cabinet Secretary for Interior, and therefore he did not satisfy the constitutional eligibility criteria, rendering his nomination null and void ab initio. It was the organization's further submission that at the material time in October 2024, the IBC was not fully constituted and it lacked the requisite number of commissioners, as the previous commissioners had resigned or retired. Articles 82 and 88 establishes a constitutional architecture requiring a lawful and fully constituted IBC to oversee electoral and nomination processes, and that the Supreme Court in IBC versus AG Advisory Opinion number 4 of 2024, reported 2025, held that a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It submitted that the exercise of constitutional functions reserved for the Commission under Article 88, Sub-Article 4, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum. It was further submitted that in the absence of commissioners, IBC was constitutionally incapable from undertaking its mandated electoral processes, and that the approval of a deputy president nominee, the second highest constitutional office, is no less a substantive constitutional responsibility than the limitation of boundaries. The same principle applies with equal force. The organization urged this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, Sub-Article 3b in the Dubia Pro Libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors enforcement of a right created in Jacqueline Okuta and another versus AG, High Court reported in 2017, and that it further submitted that the unconstitutional exercise of a legislative mandate cannot be shielded from judicial scrutiny, as was held in Commission for Implementation of Constitution versus National Assembly of Kenya and two others, 2013, KLR reported. In the end, the petitioner prayed that the petition be accordingly allowed. I now proceed to the 10th to 41st petitioner's case. That's yours. That's yours. Proceed.
Let me take the 10th to 41st petitioner's case. The 10th to 41st petitioners are a group of Kenyan citizens and one registered association, primarily from Central Kenya region. They filed the petition dated the 17th of October 2024. That was amended on the 18th of June 2025, re-amended on the 16th of December 2025. They challenged the constitutional validity of the impeachment process and subsequent removal of H.E. Gachagua as Deputy President of Kenya, stating that the National Assembly and the Senate failed to comply with Article 152 of the Constitution, which requires them to modify the presidential impeachment procedure under Articles 144 and 145 for the Deputy President. They said that instead they applied the same rules under Standing Orders 64 and 65 for the National Assembly and Standing Orders 78 and 79 for the Senate without necessary modifications, ignoring prestige or legal immunities as the President. The petitioners avowed that this failure rendered the entire impeachment process invalid, null and void ab initio, and violated the right to a fair hearing under Articles 25, 27, and 50. It was their further position that the impeachment was not a genuine parliamentary process, but was engineered, sponsored, and bulldozed by political and financial inducements to capture Parliament, turning it into a tool to remove the DP and settle political scores, thereby subverting the sovereign will of the people who elected the Deputy President in the August 2022 general election. They asserted that the President and the Deputy President were elected on a joint ticket and that the impeachment violated the rights of the petitioners and other voters from the Central Kenya region who voted for that joint mandate. The petitioners also highlighted and incorporated arguments from Nairobi High Court Constitutional Petition 356 of 2024. In that matter, it was alleged that both H.E. President Ruto and H.E. Gachagua had violated their oaths of office and the Constitution through various actions. Specifically, it was claimed that the President accepted foreign gifts valued at approximately Kenya shillings 240 million in the form of paid-for jet hire and fuel costs for a state visit to the United States, thereby exceeding the legal threshold permitted for such gifts. It was further alleged that the President entered into a secretive treaty with the United States to designate Kenya as a non-NATO ally without tabling the agreement before the National Assembly and Senate as required by constitutional oversight. Additional claims included intimidation and threats directed at members of Parliament to bypass oversight, as well as inducement of political defections to artificially control the majority party coalition. The petitioners accused the President of using state violence to criminalize and suppress the Gen Z, otherwise read the Generation X, good governance protests, as well as the July 2023 protest against oppressive taxation and the high cost of living, and that he distributed state appointments along acute ethnic lines. Additionally, H.E. Gachagua was faulted for publicly dividing Kenyan citizens into shareholders and non-shareholders in quotes based on political alignments, whereas H.E. President Ruto is accused of spending hundreds of millions of public funds to conduct avoidable by-elections caused by appointing sitting MPs and senators to the cabinet. The petitioners further argued that the agreement binds H.E. President Ruto to nominate Deputy President from the Gikoyo, Embu, Omeru communities, which is the same region as the impeached Deputy President. They sought a declaration that the President's power to nominate a new Deputy President was subject to certification by the IEBC, that the nominee meets qualifications under Articles 99 and 137, stating that the 14-day and 60-day timelines in Article 149 were meant to ensure public participation across all 90 constituencies. Consequently, the petitioners asked the court to declare the nomination and approval of H.E. Kindiki as the new Deputy President as unlawful, null and void. The petitioners thus sought the following reliefs from this court. 1. A declaration be issued to declare that the first petitioner was impeached by the National Assembly and removed by the Senate under a procedure that violated Articles 27, 50, and 150 sub-Article 2 of the Constitution. 2. A declaration be issued to declare that the first and second respondents have violated the rights of the petitioners and other voters and residents of Central Kenya region by failing to govern together in accordance with their joint mandate secured during the presidential election held on the 9th of August 2022. 3. A declaration be issued to declare that the first petitioner was impeached by the Parliament under the respective standing orders of the National Assembly and the Senate that offends Article 150 sub-Article 2 of the Constitution. 4. A declaration be issued to declare that the impeachment of the first petitioner was null and void ab initio on account of the violation of Articles 25, 27, and 50 of the Constitution, read together with Articles 144, 145, and 150 of the Constitution. 5. A declaration be issued to declare that the second and third to 14th respondents have conspired and schemed to remove the second respondent from office through impeachment in violation of Articles 1, 27, and 38 of the Constitution. 6. A declaration be issued to declare that the second respondent violated Articles 110, 118, and 150 of the Constitution in passing a resolution on 8th October 2024 to remove the second respondent from office. 7. An order of certiorari be issued to quash the resolution of the second respondent passed on 8th October 2024 to approve the motion of impeachment of the first petitioner tabled on 1st October 2024 by the 9th respondent. 8. A declaration be issued to declare that the 6th respondent's power under Article 149 of the Constitution to nominate a person to occupy the office of the Deputy President is subject to certification by the Independent Electoral and Boundaries Commission under Articles 99 and 137 of the Constitution. 9. A declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office of Deputy President is to ensure compliance with Articles 10, 38, 99, and 1. A declaration be issued to declare that the 60 days period prescribed under Article 149(1) of the Constitution for the National Assembly to vote on the President's nomination to fill the vacancy in the office of the Deputy President is to ensure compliance with the requirement of public participation in all the 290 constituencies in accordance with Article 1, 10, 27, 38, 118, and 136 of the Constitution. 11. That by dint of Articles 1, 10, 27, and 38 of the Constitution, the first respondent is bound by the Kenya Kwanza Coalition Agreement dated the 5th of April 2022 to nominate a qualified person from either of the Gikuyu, Embu, and Meru communities to fill the vacancy in the office of the Deputy President occasioned by the impeachment of the second respondent. 12. A declaration be issued to declare that the 6th respondent's nomination and of approval, therefore, by the National Assembly of H.E. Honorable Kithure Kindiki, the second interested party herein, as Deputy President is unlawful, null and void ab initio. 13. The Honorable Court be pleased to issue an order of certiorari to quash the nomination by the National Assembly of Honorable Kithure Kindiki as a Deputy President via Gazette notice published in a special issue of the Kenya Gazette dated 18th October 2024. And 14, a declaration be issued to declare that by dint of Articles 1, 10, 27, 38, 91, and 132 of the Constitution, the citizens of Kenya from the Gikuyu, Embu, and Meru communities have a right secured by the results of the presidential election held on 9th August 2022 to have one of them to occupy the office of the Deputy President during the tenure of the first respondent as the President of Kenya. 15, a declaration be issued to declare that Standing Orders number 64 and 65 of the National Assembly Standing Orders violates Article 152 of the Constitution. 16, an order of certiorari be issued to quash Standing Orders 64 and 65 of the National Assembly Standing to the extent that they apply to the Deputy President. 17, a declaration be issued to declare the Standing Orders 8 and 79 of the adopted of June 2024 violates Article 152 of the Constitution. 18, an order of certiorari be issued to quash Standing Orders number 78 and 79 of the Senate as adopted on 16th June 2024 to the extent that they apply to the Deputy President. 19, an order of mandamus be issued to compel the National Assembly and the Senate, that is the second and fourth respondents herein, to promulgate a procedure for removal of the Deputy President, impeachment envisaged by Article 152 of the Constitution. 20, that a declaration be issued to declare that the first petitioner was impeached through a procedure amounted to political vendetta prescribed by Articles 1, 3, 38 of the Constitution. 21, that a declaration be issued to declare that the sixth respondent engineered, sponsored, opposed the impeachment of the first petitioners in a manner that amounts to abuse of power in violation of Article 3, 38, 50 and 131(2) of the Constitution. 22, cost of the petition be borne by the first and respondents. The 10th and 41st petitioners' submissions. In these submissions, the petitioners reiterated that the impeachment proceedings did not stem from legitimate constitutional violations. Instead, they arose directly from a severe political fallout and a politics of betrayal, in quotes, between HE President Ruto and HE Gachagua. They submitted that the impeachment motion was assigned to MP Honorable John Waluke, but however, due to his tainted image from a high-profile corruption case, Honorable Mutuse was brought in as a substitute mover to table the motion on the 1st of October 2024. The petitioners listed the following issues for determination. A, whether the impeachment of H.E. Gachagua was a political witch hunt or a genuine procedure. B, whether H.E. Gachagua was impeached in the Assembly and the Senate under a procedure that violated Articles 27, 50 and 152 of the Constitution. C, whether H.E. Gachagua was lawfully found guilty of ground 1 of the Articles of Impeachment. D, whether the Standing Orders number 64 and 65 of the National Assembly, Standing Orders number 78 and 79 of the Senate, under which violate Article 152 of the Constitution. E, whether the Senate's failure to establish a special committee under Article 145(6) of the Constitution rendered the removal of H.E. Gachagua as null and void ab initio. Issue F, whether H.E. Gachagua was subjected to a lawful and fair trial by the Senate. G, whether the first to 11th respondents schemed to remove H.E. Gachagua from office in violation of Articles 1, Article 27, and 38 of the Constitution. On the weaponized impeachment for political settlements, the petitioners maintained that the impeachment was completely manufactured by a political fallout rather than the genuine existence of any lawful grounds under Article 151 of the Constitution. That it was the executive and parliament used the sacred device of impeachment as an administrative tool of purely political disputes and vendetta. They submitted that the impeachment proceedings inside both the National Assembly and Senate were and conducted in absolute violation of procedural guaranteed under the Constitution, as well as the standing orders of both. Specifically maintained that the current rules governing the process, that is, Standing Orders 64 and 65 of the National Assembly and Standing Orders 78 and 79 of the Senate, violate Article 150 sub-Article 2 of the Constitution and must be quashed. They submitted that H.E. President Ruto's power to nominate a replacement under Article 149 was strictly subject to certification by IEBC under Articles 99 and 137, and because the 14-day and 16 constitutional windows of Article 149 are designed to guarantee rigorous public participation across all 290 constituencies, the rushed nomination of H.E. Kindiki was unlawful. It was null and void ab initio. That rushing this process directly violated the rights of the under Article 38. Petitioners argued that this court has an obligation to step in and quash the impeachment to halt an ongoing executive scheme to re-establish imperial presidency in Kenya, and they warned that Parliament has become subservient and sycophantic to the executive, acting like the single-party parliament of the late 1980s and existential to Kenya's constitutional democracy. The prayers declare the impeachment null, void, and an act of political persecution. 7 the Constitution and orders of certiorari quashing the National Assembly's 8th October 2024 resolution approving the impeachment motion and Gazette notice which appointed H.E. Kindiki as Deputy President. They also sought to quash the National Assembly Standing Orders 64 and 65 and Senate Standing Orders 78 and 79 to the extent that they apply to the removal of a Deputy President and orders to compel both chambers of Parliament to promulgate a legally compliant, constitutionally envisaged procedure for removing a deputy president under Article 150 sub-Article 2. The petitioners relied on various local authorities, including the Sonko case earlier mentioned, as well as Jirongo versus Soy Developers Limited. They also relied on foreign authorities, including Kriegler versus the Law Society of Alberta, Republic R versus Budry, R versus Campbell, R versus Reagan, all of which citations you will find in the judgment, all from the Supreme Court of Canada. Further reliance was placed on books, articles, speeches, and reports, as well as interview statement by the Senate floor as per the Hansard of 9th October 2024 and an interview statement by H.E. Gachagua on Inoro TV. In the end, the petitioners prayed that their petition be allowed as prayed. Moving on to the 43rd petitioner's case, Mr. Morara Omoke filed a petition dated 9th October 2024 before the High Court of Kenya at Eldoret, together with a supporting affidavit sworn on the same date in his capacity as a Kenyan citizen and acting in defense of constitutionalism, the rule of law, and democratic governance. The petition challenged the constitutionality and legality of the impeachment proceedings commenced against H.E. the National Assembly and Senate. He claimed that the process was politically motivated, effective, unconstitutional, and undertaken in violation of the sovereign will of the people expressed during the 2022 general election. His case centered on the alleged violations of Article 1, 10, 38, 47, 48, 50, 73, 75, 94, 118, 145, and 150 of the Constitution, that the impeachment motion tabled by the Honorable Motuse had not been preceded by adequate public participation, and that the MPs who appended their signatures in support of the motion failed to consult their constituents before supporting the impeachment process. He further alleged that the collecting signatures in support of the impeachment motion was tainted by bribery, undue influence, intimidation, and forgery of signatures belonging to some MPs. He contended that the subsequent public participation exercise conducted on 4th and 5th October 2024 was merely cosmetic and incapable of constituting meaningful public participation because it was hurried, poorly coordinated, inadequately published, conducted through only one center per county and constituency. He also complained that the public participation forms contained only the allegations against H.E. Gachagua and omitted his responses, thereby condemning him unheard and violating the principles of fairness and natural justice. He also alleged bias and conflict of interest on the part of the Speaker and the National Assembly. He contended that both office holders publicly supported the impeachment process before the motion was tabled and debated in Parliament, thereby compromising their constitutional obligation to act as neutral and impartial arbiters during the proceedings. He asserted that the impeachment motion was politically motivated and arose from internal disputes within the UDA party, yet the parties involved had failed to exhaust internal party dispute resolution mechanisms under the party constitution before initiating proceedings. He also argued that there existed no comprehensive statutory framework governing impeachment proceedings and the collection of signatures for impeachment motions, thereby rendering the process legally deficient and constitutionally uncertain. Mr. Omoke then sought the following orders. A declaration that the impeachment motion moved by the third respondent does not meet the threshold set out in Article 145 as read with Article 150 of the Constitution. B, a declaration that the impeachment of Geoffrey Rigathi Gachagua was unconstitutional. C, a declaration that the Speaker and Deputy Speaker of the National Assembly were biased and ought to have disqualified themselves from the impeachment process. D, a declaration that the impeachment motion violated the interested parties' rights under Article 32, 33, 38, 47, 48, 50, 73, and 75 of the Constitution of Kenya 2010. E, a declaration that the impeachment motion against the interested party was tabled in a manner that violates Article 110, 94, and 118 of the Constitution, as no public participation was conducted by Honorable Mutuse, Ekomas Mwengi, and by the members who appended their signatures prior to moving the impeachment motion in the National Assembly. F, a declaration that the impeachment motion, which was a result of a dispute in the United Democratic Alliance Party, was tabled before the National Assembly without exhaustion of internal remedies, contrary to the exhaustion doctrine and Article 159 of the Constitution of Kenya. G, a declaration that in the absence of an enabling legislation operationalizing the provisions of Article 150 of the Constitution of Kenya, there is no legislative and administrative framework within which the impeachment of the DP was anchored, and each party bears its own costs. In his submissions, Mr. Omoke focused on two main issues, namely, whether the impeachment of H.E. Gachagua was unconstitutional and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. He wholly adopted H.E. Gachagua's submission October 2025, submitting that the constitutionality of the impeachment transcends him and must be evaluated with a view to advancing constitutionalism and the rule of law. He maintained that public participation was inadequate and a sham, as the mover of the motion and the 291 MPs who appended their signatures in support of the impeachment motion did not conduct any public participation before signing, contrary to Articles 1, 10, 94, and 118 of the Constitution. That public participation was an afterthought, and when questions are directed that it be held on 4th October 2024. The advertisement appeared on 2nd October 2024, which Mr. Omoke submitted was not a genuine intention to conduct any real public participation from the outset. That the public participation form provided by the National Assembly contained only the allegations against H.E. Gachagua and conveniently left out his response, denying the public the ability to effectively weigh the grossness of the alleged violations. He submitted that public hearings of 9 hours on a normal one, which was most venues from AD Hall to Talent Academy, and in Nairobi changed from KICC to Bomas of Kenya. He submitted that in Kiambu constituency, only about in a county with over 1 million registered voters, that there was no proper coordination, and he described the situation as utter pandemonium akin to the Tower of Babel. He contended that in some areas, especially in Mount Kenya, public participation forms were faulty. There were incidents of pre-filled forms, and a vehicle ferrying pre-filled forms was torched in Nyeri County. That the National Assembly extended the exercise to the following day, on the 5th of October 2024, but no proper notification was made, and MPs he asked West Mugiranga, the MP never opened the constituency, and that the other, the one center per county and one as public participation conducted at least at each polling station or at minimum each ward. Mr. Omoke submitted that the National Assembly neither processed, nor considered the feedback collected, and the entire exercise was a mere sham to hoodwink innocent Kenyans. He accused Deputy Speaker Gladys Bose-Shulei of being biased in that on 23rd September 2024, while speaking at a function in Uasin Gishu County, she swore to spearhead the impeachment motion and put the Deputy President on notice, stating, in quotes, mimi mwenyewe nitakupeleka nyumbani. In brackets, I will personally take you home. That she also hinted at some of the grounds of impeachment before the motion was even tabled. He further argued that Speaker Moses Masika Wetangula on 29 September 2024, while attending a church function at Wamonyo Catholic Church in Machakos County, publicly took a stand on the impeachment motion before it was tabled. Using the biblical description in Mark 9:38-50, he stated that H.E. Gachagua, being a part of the body that leads to sin, should be cut off. These utterances he submitted violated Articles 47, 50, and 150 of the Constitution, and that neither the Speaker nor the Deputy Speaker should have presided over the impeachment motion. Mr. Omoke submitted that the Constitution sets a high threshold for impeachment as the measure is a grossness of alleged violations and that grudges and squabbles cannot be the basis for removal. He contended that extraneous grounds were introduced on the floor on 8 October 2024, as it was alleged that H.E. Gachagua had referred to Honorable Florence Jemataya Sergon, the countrywoman rep of Baringo, a harlot. That Honorable Karoli Omondi, MP Suba North, referred to conversations he had with H.E. Gachagua without providing any proof. Honorable Patrick Makau, MP Mavoko, also made references to conversations without providing any proof. On the vote, and there was one absentee, Mr. Omoke submitted that MPs abdicated their obligation to weigh the grounds against the intermediate standard of proof set by the Supreme Court in Odinga and 5 others versus IEBC and 3 others. That the impeachment overturned the decision of 7,176,141 Kenyans who voted for the joint ticket on 9 August 2022, a decision upheld by the Supreme Court, and that the motion was an egregious overthrow of the decision of the majority with that of a few. It was Mr. Omoke's further submission that no statutory legislation exists on the process of impeachment of the President and Deputy President from start to completion, as no legal framework exists on the collection of signatures in support of an impeachment motion. Therefore, there is no framework upon which the impeachment of the Deputy President was anchored. He submitted that indeed, and others, but is the Attorney General, this court was persuaded by Mr. Omoke, who was a petitioner therein, that the lack of legislation on signature collection and verification and on the conduct of referenda initiated the BBI process. He submitted that the same principle applies and that legislation is so central to the fairness of the process that the court ought to, at minimum, issue a structural edict requiring enactment of this legislation. He submitted that areas requiring legislation include initiation of the impeachment process, how Parliament is to process impeachment, particularly public participation, and the actual impeachment trial, the replacement of an impeached Deputy President, provision for judicial intervention before an impeached President or Deputy President is replaced, including grant of conservatory orders to preserve the rights of the impeached official, and expeditious hearing of petitions arising from an impeachment. Mr. Omoke saw no reason why the court could not have maintained conservatory orders in favor of H.E. Gachagua and had the petitions within a week or 2. That the discharge of the orders, followed by an immediate declaration of a public holiday for the swearing-in of a new deputy president left a mind-boggling question on the efficacy of Article 50 of the Constitution. For these reasons, for a declaration that the impeachment of H.E. Gachagua was unconstitutional, and that a declaration that the absence of legislation operationalizing Article 150 of the Constitution rendered the impeachment process of the Deputy President flawed. Kennedy Kareli Gachagua, Dennis Okumu, Simon Mushangi, and Peter Maina Kanene jointly filed the petition dated September 2024 before the High Court of Kenya at Nairobi. They describe themselves as Kenyan citizens committed to the rule of law and defense of the Constitution, and that they also instituted the petition in the public interest to challenge the proposed impeachment of H.E. Gachagua as Deputy President of the Republic of Kenya. As part of their petition and the supporting affidavit sworn by Omuli Namenya, the petitioners challenged the constitutionality of the impeachment process on the basis that Parliament has failed to establish a proper legal and procedural framework governing public participation in impeachment processes under Article 118 and 124 of the Constitution. The petitioners contended that neither the National Assembly standing orders nor the Senate standing orders provided mechanisms, procedures, thresholds, timelines, verification methods, venues, or modalities for meaningful public participation in impeachment proceedings, thereby rendering contemplated impeachment process unconstitutional. They further argued that public participation was a mandatory constitutional prerequisite which ought to protect the impeachment process, and asserted that the 7-day timelines prescribed under Standing Orders 64 and 73 for disposal of impeachment proceedings were inadequate and unconstitutional, as they undermined effective public participation and violated the rights to fair administrative action and fair hearing under Articles 47 and 50 of the Constitution. The petitioners additionally alleged that the impeachment process was politically motivated and tainted by bias and lack of impartiality on the part of parliamentary leadership, citing public pronouncements by parliamentary leaders in support of the impeachment motion. They advanced a historical argument concerning the office of the Vice President and Deputy President in Kenya, contending that successive Deputy Presidents had historically been subjected to political hostility. Design of 2010, requiring the President and Deputy President to be elected jointly. The petitioners then sought the following prayers: A declaration that the impeachment process of a deputy president is a sui generis in nature, and that public participation forms a fundamental background that plays a significant role in attaining the right to a fair trial enshrined under Article 50 of the Constitution. B, a declaration that public participation is the only avenue or means through which the people can exercise their sovereignty contemplated under Article 1 of the Constitution in determining whether an office created under the Constitution ought to be abolished, or whether accountability mechanisms created under this Constitution ought to be put in motion or otherwise, and that the lack of elaborate procedure or certainty as to when the same should commence or conducted will ordinarily amount to usurpation of the people's power and subsequently amount to violation of the Constitution. C, a declaration that the Article 118 sub Article 2 that clearly provides for mandatory public participation, and Article 124 creating the requisite parliamentary standing orders. Neither the National Assembly nor the Senate have enacted an Act of Parliament providing for the procedure on how the impeachment of either the President or Deputy President is to be undertaken, nor has the National Assembly Standing Order 64 or 65 or the Senate Standing Order number 74 provided for the procedure governing the crucial element of public participation relating to the impeachment of a Deputy President. D. A declaration by the National Assembly Standing Order 64 and 65 or the Senate Standing Order number 74 are unconstitutional as they were never subjected to the mandatory public participation during their enactment. E. A declaration that the standing orders must with certainty and clarity provide that the public participation contemplated under Article 118 should be a conditional precedent that must precede all other processes relating, connected, or incidental to the impeachment of the Deputy President. F. A declaration that Article 27 requires that all Kenyans must be subjected to the principle of equality and equal protection of the law, while Article 47 requires that a person must be subjected to an administrative process that is procedurally fair, expedited, reasonable, and lawful, irrespective of one's status in society, and that the respondents herein have violated the same by commencing an impeachment process that is constitutionally tainted with illegalities. G. A declaration that public participation in an impeachment process is a fundamental infrastructure that facilitates the enjoyment of Article 50 and that the absence of the same will amount to the respondents hearing violating, denying, threatening, or infringing the interested party's right to a fair trial during his impeachment. H. A declaration that time is an important resource for any judicial or quasi-judicial tribunal contemplated under the Constitution, and that the 7 days period for impeachment provided for under Standing Order 64(2)(b) of the National Assembly Standing Orders and the Senate Standing Order 73(1) amounts to conducting a sham trial in, and the same will amount to a violation of Article 50. I. A declaration that Standing Order 64(2)(b) of the National Assembly Standing Orders and the Senate Standing Order number 73(1) does not provide for the sufficient and adequate time for carrying out a qualitative, quantitative, meritorious, accurate, and secure public participation, the hearing and determination of the impeachment trial before Parliament that will result into a fair, just, impartial, and judicious determination of the impeachment trial as contemplated under Article 47 and 50 of the Constitution. J. A declaration that for purposes of authenticating and verifying the results of the participants taking part in the public participation, confirming all the requisite legal thresholds like that of citizenship, the total number of participants, public participation ought to be undertaken by an impartial state organ separate from Parliament. Looking at the 44th to 48th petitioners' submissions, led by Learned Counsel Mr. Njiro Ndegwa, the petitioners focused on the constitutional architecture governing impeachment of a deputy president, submitting that the process was fundamentally flawed because impeachment is a measure of last resort, not a primary accountability tool, and that the Senate failed to apply the mandatory modification rule under Article 152, which requires that Articles 144 and 145 be applied in quote with necessary modifications to the Deputy President. Mr. Ndego submitted that the proceedings violated fair hearing rights under Article 50, including the refusal to adjourn when the Deputy President fell ill, that the process was infected with bias, irrelevant considerations, and procedural violations of the Standing Order 75, 78, and 80, and that the cumulative defects render the entire impeachment null and void. The petitioners adopted and relied on H.E. Gachagua's submissions and the Wambora principles on quasi-judicial impeachment proceedings and identified the following issues for determination. Whether the impeachment of the Deputy President met the constitutional threshold of a measure of last resort in light of the availability of alternative constitutional and statutory mechanisms. Whether the constitutional framework governing the impeachment of a Deputy President under Article 150 sub-Article 2 was properly invoked, applied, and distinguished from the regime governing the impeachment of a President under Article 145. Whether the Senate complied with the mandatory requirement to apply Articles 144 and 145 with necessary modifications as contemplated under Article 152 and Standing Order 79. Whether the failure to apply the modification rule undermined the constitutional principles of sovereignty of the people, national values, and political rights, including the legitimate expectation of tenure. Whether the impeachment process satisfied the constitutional and jurisprudential standards applicable to quasi-judicial proceedings as articulated in the Wambora decisions. Whether the Senate's failure to comply with constitutional requirements renders the impeachment process null and void. Whether the impeachment process violated the Deputy President's right to equality and equal protection of the law under Article 27. Whether Parliament, in conducting the impeachment proceedings, acted as an impartial and unbiased quasi-judicial body as required by law. Whether the debates and proceedings in both the Senate and the National Assembly were confined to the substantiation of the charges or were contaminated by irrelevant, extraneous, and prejudicial considerations. Whether the refusal to grant an adjournment upon the Deputy President falling ill violated his right to a fair hearing under Article 50, including the right to be present and to be adequately present, to adequately present his defense. Whether the Senate misapplied Standing Order 78 by proceeding under a plenary hearing without affording procedural safeguards and by improperly treating the proceedings as time-bound. Whether the impeachment proceedings violated the Deputy President's right to adequate time and facilities to prepare a defense under Article 50, sub-Article 2A, and the right to be heard under Standing Order 80. Whether the Senate acted in violation of its own standing orders, including Standing Order 75, 78, and 80, and the legal effect of such violations. Whether sufficient time existed within the constitutional and procedural framework to accommodate adjournment and ensure a fair hearing, and whether failure to utilize such time rendered the process unconstitutional. Whether the continuation of proceedings in light of the Deputy President's illness violated his fundamental rights to life, dignity, health, and access to justice under Articles 26, 28, 48, and the state obligations under Articles 10, 19, 20, and 21. And finally, what reliefs are available where a constitutional Learned Counsel submitted that impeachment is not intended to be a primary or convenient mechanism for addressing alleged misconduct, but rather an extraordinary remedy reserved for the clearest and most compelling cases where no other lawful avenue exists. They argued that the Constitution establishes a graduated hierarchy of accountability, beginning with civil liability, criminal prosecution, and administrative action, and only thereafter impeachment. It was emphasized that Article 143 expressly removes immunity from civil and criminal proceedings for the Deputy President, unlike the President. According to Mr. Ndegwa, this signals that allegations against the Deputy President should, in the first instance, be addressed through ordinary legal processes. Parliament, however, bypassed these mechanisms and resorted to impeachment as a first recourse, which Council contended offends the principles of proportionality, rationality, and legality. They further submitted that no evidence exists that Parliament considered whether the allegations could have been addressed through criminal investigation or civil proceedings before invoking impeachment. Council also drew attention to Article 152, which provides that Articles 144 and 145 apply to the Deputy President with the necessary modification. Council argued that this phrase is not ornamental, but a deliberate constitutional command requiring contextual adaptation of the presidential impeachment framework to the distinct office of the Deputy President. In their view, the requirement imposes an active obligation on the Senate to interrogate, adjust, and tailor the procedure rather than merely transplant it without reflection. Standing Order 79, they submitted, operationalizes this obligation by requiring the Senate to consciously and expressly apply the modification principle. Mr. Ndegwa submitted that nowhere in the Senate Hansard is the Speaker recorded as guiding the House on the necessity, the scope or content of the required modifications as the Senate proceeded, as though Article 145 applied mutatis mutandis and in total without any modification. He stated that this failure is not merely procedural, but a substantive and jurisdictional issue which renders the entire process unconstitutionally defective ab initio. The petitioner submitted that this modification requirement ensures that impeachment is not invoked where alternative legal mechanisms such as the courts, EACC, or DCI are adequate. It was their case that the failure to modify denied the Deputy President the procedural safeguards that would have arisen from a properly tailored process, including consideration of alternative accountability mechanisms, flexibility in procedure to ensure fairness, and enhanced scrutiny of the necessary and proportionality of the impeachment. It was their submission that the office of Deputy President derives its legitimacy from the sovereign will of the people expressed at the ballot under Article 1, and impeachment without proper modification undermines this sovereign will and defeats the legitimate expectation of tenure for both the office holder and the electorate. That Article 38 guarantees citizens the right to elect leaders and to have them serve their full term, subject only to lawful and constitutionally compliant removal process, and that the failure to modify the process resulted in an unjustified interruption of the people's sovereign mandate. Mr. Debwa submitted that the Deputy President fell ill during the proceedings while actively engaged in his defense, and that this is not disputed and is recorded in the Senate Hansard. That the Senate refused to grant an adjournment, proceeding instead to a conclusion in his absence, and he submitted that this violated Article 52 on the right to adequate time and facilities to prepare a defense, and Article 52F on the right to be present when being tried, and Standing Order 80 on the right to be heard within Senate proceedings. That a hearing conducted in the absence of the principal defense participant due to verified illness cannot satisfy the conditional threshold of fairness. He stated that the Senate had sufficient procedural latitude under Standing Order 75 to adjourn without violating any constitutional timeline, but the refusal was not dictated by lack of time, but by a failure to exercise discretion fairly. The petitioner submitted that under Article 26 on the right to life, the state must refrain from actions that undermine physical well-being or exacerbate medical vulnerability, and that proceeding with impeachment during illness reduce the Deputy President to a procedural object rather than a rights-bearing participant. They stated that Article 48 on the access to justice extends to all adjudicated processes, including parliamentary impeachment, and that meaningful participation requires reasonable accommodation and denial of adjournment rendered access to justice illusory. They also submitted that the test for bias is objective, and whether a reasonable and informed observer would apprehend bias, and that senators acknowledged imperfections in the case but still voted to impeach, which demonstrated bias. They urged the court to address the impeachment process as a whole, not in fragments, noting that the petitioners have demonstrated cumulative defects, including failure to apply the modification rule under 152, absence of impartiality and presence of bias, reliance on irrelevant and extraneous considerations, violations of fair hearing rights, misconstruction of the constitutional and procedural framework, and breach of Standing Orders 75, 78, and 80. They submitted that individually, each defect is serious, and collectively, they reveal a process that is constitutionally unsound from inception to conclusion. That Article 165 3D, Roman 2, vests the High Court with jurisdiction to determine whether anything done under constitutional authority is inconsistent with or in contravention of the Constitution. They contended that this court is not being invited to interfere with parliamentary politics, but is being invited to perform its core constitutional function as guardian of legality and fundamental rights, and where Parliament acts within constitutional bounds, the court defers, but where it acts outside those bounds, the court must intervene, not as an intruder, but as a constitutional necessity. As such, the petitioners urged the court to find that impeachment was not a measure of last resort when ordinary legal mechanisms were available and bypassed, that the Senate failed to apply the mandatory modification rule under Article 152, rendering the process unconstitutional ab initio. The refusal to adjourn during illness violated Articles 50, 26, 28, and 48, that the proceedings were infected with bias and irrelevant considerations, and that the cumulative defects render the impeachment null, void, and of no legal effect. They then prayed that their petition be allowed in entirety.
from the 51st petitioner's case. Caroline Wambui Mwangi, the 51st petitioner, in the consolidated petitions, filed the petition dated 26th of September 2024 before the High Court of Kenya at Milimani as a public-spirited Kenyan citizen and a defender of the Constitution. Ms. Mwangi contended that the impeachment process was unconstitutional, unlawful, and politically motivated. She relied on public statements allegedly made by Honorable Didmas Baraza and Honorable Gladys Posholei in September 2024, indicating that the impeachment of H.E. Gachagua had already been predetermined, and further referred to a motion by Honorable Danson Mungatana expressing displeasure with the conduct of His Excellency Gachagua. Ms. Mwangi asserted that the allegations leveled against his H.E. Gachagua were vague, unsupported by evidence, and lacking in specificity and peculiarity, contrary to the constitutional requirements of fair hearing and due process under Articles 47 and 50 of the Constitution. She further alleged that the intended impeachment process mounted to a political witch hunt designed to settle political scores rather than a lawful constitutional process, and contended that the respondents had violated the national values and principles under Article 10, including the rule of law, transparency, accountability, equality, and protection of human rights. She maintained that His Excellency Gachagua had not been accorded adequate notice of the charges against him, sufficient particulars of the allegations, nor an opportunity to adduce and challenge evidence in violation of Articles 25C, 35, 47, and 50 of the Constitution. As such, she sought for the following orders. A declaration that within the purview of Articles 25C, 35, 47, and 50 of the Constitution of Kenya, a person facing impeachment proceedings under Article 150 is entitled to be informed substantially with peculiarity and specificity, and supported with evidence the grounds of impeachment before the commencement of the impeachment proceedings by the National Assembly and Senate. B, conservatory orders do issue against the respondents, restraining them from a collection of signatures in support of a motion to impeach His Excellency Rigathi Gachagua, lodging any motion and or carrying on proceedings seeking to impeach the Deputy President of the Republic of Kenya, the interested party herein. See, an order of compensation enshrined and provided for under Article 23A of the Constitution of Kenya, made up of damages as shall be assessed and quantified by the petitioner, general damages, cost of the petition, and any other relief. The 51st petitioner neither filed any written submission nor attended the physical highlighting of submissions. In respect to the 54th petitioner's case, Emmanuel Elijah Otieno was the 54th petitioner in the consolidated petitions. He is an advocate of the High Court of Kenya who filed the petition dated 18th of October 2024, together with a supporting affidavit also challenging the constitutionality and legality of the impeachment and removal from office of His Excellency Gachagua as Deputy President. He stated that instituted proceedings in the public interest pursuant to Articles 3 and 258 of the Constitution, and contended that impeachment process undertaken by the National Assembly and the Senate was procedurally unfair, politically motivated, unconstitutional, and inconsistent with the constitutional principles governing impeachment under Articles 145 and 50 of the Constitution. He maintained that impeachment was a constitutional mechanism intended to promote accountability and good governance, and not a tool for settling political disputes or managing political differences among leaders. He challenged the legality of public participation process and the fairness of the proceedings before the National Assembly and the Senate, and the substantive threshold applied in removing His Excellency Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required under Articles 10 and 118 of the Constitution and Section 5 of the Fair Administrative Actions Act. Mr. Otieno stated that the public participation exercise was hurried, inadequate, both quantitatively and qualitatively, and incapable of reflecting the sovereign will of the electorate. given that only about 223,000 persons participated, despite His Excellency Gachagua having been elected together with His Excellency President Ruto by over 7 million voters. He further asserted that the public participation template prepared by the National Assembly was biased because it only contained the allegations against His Excellency Gachagua and failed to include his responses, thereby portraying him to the public as guilt before he had been heard. Mr. Otieno additionally stated that the Speaker, Deputy Speaker, and members of National Assembly demonstrated bias from the outset, failed to accord His Excellency Gachagua a fair hearing, and debated the impeachment motion before proper public participation and before considering His Excellency Gachagua's defense. He maintained that no impeachable offense meeting the constitutional threshold of gross violation, gross misconduct, or commission of crimes under national or international law had been substantiated either before the National Assembly or the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the rights of fair hearing and fair administrative action. He sought the following prayers: A declaration be and is hereby issued that the public participation organized and conducted by the first respondent did not meet the requirements of Articles 118, 1B of the Constitution quantitatively and qualitatively. B, a declaration be and is hereby issued that the first respondent violated seventh respondent right to a fair administrative action under Articles 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. C, a declaration be and is hereby issued that the first respondent violated the right of the seventh respondent under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration be and is hereby issued that the resolution of the first respondent to impeach the seventh respondent was invalid and null and void. And E, respondent shall bear the cost of the petition. Likewise, the 54th petitioner neither filed any submissions nor attended the physical highlighting of the submissions. Next is consideration of the 55th and 56th petitioner's case. Stephen Mbugua Wanjiru and Gladys Nyambura Gituha jointly filed the petition dated 20th of October 2024 together with the supporting affidavit sworn by Wambugu Wanjohi. They stated that they were public interest litigants and defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination and approval process relating to His Excellency Kindiki as the Deputy President nominee. The petitioners contended that the impeachment process before both the National Assembly and the Senate were marred by procedural irregularities, bias, denial of fair hearing, and unconstitutional conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the constitutional principles of impartiality, neutrality, and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachagua without his responses, and that the Parliament failed to avail documentary and electronic evidence to the public to facilitate informed participation. He further asserted that the Senate proceedings he further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and that by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit, but I'll proceed from paragraph 133. They additionally alleged that public participation process was chaotic, disorderly, and marred by violence and characterized by low turnout in several constituencies and undertaken on days when many Kenyans were engaged in religious worship, thereby undermining the constitutional threshold for meaningful participation under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate proceedings. They contended that the Senate acted in violation of Articles 25C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing despite His Excellency Gachagua's illness and hospitalization, and thereby denying him an adequate opportunity to personally defend himself. Further, the petitioners alleged bias and conflict of interest arising from participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the Senate proceedings, stating that their roles compromise the fairness and impartiality of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of parliament were characterized by constitutional violations, procedural inconsistencies, and disregard for due process. The petitioners also challenged the subsequent nomination and approval of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural violations that affected the impeachment process and was therefore null and void. As such, they sought the following prayers: a declaration that the grounds of impeachment laid in the special motion dated 24th of September 2024 did not meet the constitutional and legal threshold for impeachment of a deputy president. That a declaration do issue that public participation exercise conducted on the 4th and 5th of October was flawed and incapable of meeting the constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered a legitimate basis for advancing the impeachment motion. See, a declaration that the impeachment process against the Deputy President initiated by the National Assembly and subsequently conducted by the Senate was tainted by substantive and procedural constitutional violations, rendering unconstitutional, illegal, null and void. D, an order nullifying the impeachment of the Deputy President as the process was marred by procedural irregularities, bias, conflict of interest, and a violation of the right to a fair hearing as guaranteed under Article 50 of the Constitution. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditional and constitutionally and unlawful removed through an impugned process. F, an injunction restraining the President, the National Assembly, and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, an order revoking the nomination and subsequent approval of Professor Kindiki as Deputy President by the National Assembly, as it stems from an unconstitutional process and is procedurally flawed and in violation of the Constitution. H, a mandatory injunction directing the National Assembly and the Senate to comply with the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, declaration that the participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the impeachment proceedings violated the principles of impartiality and fair hearing and constituted a conflict of interest that compromised the integrity of the impeachment proceedings. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. The 55th and 56th petitioners did not file any written submissions, and they also did not turn up at the hearing. The 57th petitioner was Edwin Gekonge, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on the of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest and in the interest of citizens of the Republic of Kenya. The petition challenged the constitutionality of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy President. He stated that the impeachment proceedings before the National Assembly and Senate violated Articles 10, 32, 47, 48, 50, 145, and 150 of the Constitution. He stated that the public participation process conducted on the 4th and 5th October 2024 fell below the constitutional threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short, that the exercise was limited to county offices instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby excluding members of the faith from meaningful participation. He further alleged that the exercise was marred by confusion, violence, inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the first petitioner had fallen ill and was unable to continue participating in the proceedings, the Senate declined to adjourn the hearing and proceeded to vote on the impeachment charges in his absence. Mr. Gekonge stated that Article 145 of the Constitution did not prescribe rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to establish gross violation of the Constitution, gross misconduct, and serious reasons to believe that His Excellency Gachagua has committed crimes under national law. Mr. Gekonge also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki as Deputy President, stating that the constitutional timelines under Article 149 contemplated meaningful public participation and adequate vetting before approval of a Deputy President nominee. He contended that His Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gekonge sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the public participation process on the 5th of October 2024 was unconstitutional for failure to provide sufficient notice and in violation of the freedom of religion under Article 30, under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first and the second respondents was unconstitutional and did not meet the requirements set under Articles 145 and 150 of the Constitution of Kenya. D, a declaration that the impeachment process as against the first interested party undertaken by the first and the third respondents was unconstitutional as it violated Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, a declaration that the impeachment proceedings of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150, subarticle 1B. F, a declaration that the nomination of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, a declaration that the approval of the nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that the approval of the nomination of a deputy president by National Assembly under Article 149 of the Constitution must include public participation in every constituency. I, a declaration that the approval and nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional as Abraham Kithure Kindiki had not resigned as a state officer. J, a declaration that the IEBC at the time of nomination of Abraham Kithure Kindiki was not properly constituted to approve or confirm the qualification of Abraham Kithure Kindiki under Article 137(1) of the Constitution. K, a declaration that IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament as per Article 137(1) of the Constitution. L, any other orders as the court may deem just. Mr. Gikonge likewise did not file any submissions. In respect of the 50th, the 52nd and the 53rd petitioners, that is John Njomo, Clarence Eboso, and Wanjiru Mwangi, their petitions were withdrawn from the consolidated proceedings on the 7th November 2024, as well as on the 16th of May 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court's determination, being whether the National Assembly process met the constitutional threshold for meaningful public participation and Articles 110 and 118 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they meet constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural regularity of impeachment proceedings consistently with the doctrine of separation of powers. And lastly, whether the refusal to adjourn and the decision to proceed with in absentia violated the first respondent's petitioner's right to fair administrative action and fair hearing under Articles 10, 27, 28, 47, and 50 of the Constitution. Kituo cha Sheria averred that Article 118 of the Constitution mandated Parliament to facilitate public participation and involvement in legislation and all other business of the Assembly and its committees. They further argued that the removal of a deputy president from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate and directly affected the sovereign will of the people. It was their understanding that public participation in such a constitutional process had to be both quantitative to mean that a sufficient number of citizens had to be reached and accorded an opportunity to participate, and qualitative to mean that the participation had to be meaningful and capable of influencing the decision-making process. Kituo further averred that the one-day public participation notice given by the Speaker of National Assembly and the National Assembly itself was inadequate to reach a substantial portion of the Kenyan population, particularly ordinary citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without access to national media, citizens relying on vernacular radio stations, and those who depended on local public fora for information. It stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru SK Shule, and Tomboya Labour College, thereby drastically limiting accessibility and diluting representation. Kituo cha Sheria averred that the National Assembly and the Senate did not take adequate steps to ensure that sufficient citizens were made aware of the intended impeachment process. In particular, had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms for the submission of views, decentralized citizens forums, structured mechanisms for receiving memoranda from citizens across counties, and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. They deposed that in the impeachment proceedings conducted by the Senate, by the Speaker of the Senate and the Senate on the 16th and 17th of October, His Excellency Gachagua was denied an opportunity to appear and be heard, to be present when being tried, and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate, and the Senate, that is Excellency Gachagua, was present but subsequently fell ill. He was then rushed to hospital for urgent medical attention, and his legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachagua and his counsel. The Senate subsequently decided to remove His Excellency Gachagua from office by impeachment for gross misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of that the proceedings of the removal from office of the Deputy President before the Senate involved the reception of evidence, evaluation of contested facts, and the making of determinations that directly affected the fundamental rights of His Excellency. Those proceedings, therefore, ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify any allegations made. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, reached its determination without affording His Excellency those rights. Kituo cha Sheria contended that declining an adjournment request when His Excellency suffered severe and involuntary pain constituting a medical emergency was inhumane and unreasonable. They further averred that the one-day public it was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding the impeachment as conducted set a dangerous precedent by normalizing procedural shortcuts in constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty in interpreting the Constitution to adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and the public interest. They further averred that the determination of the petition would provide critical guidance on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must therefore reinforce rather than dilute the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonableness and meaningfulness and meaningful opportunity, considering the nature and the impact of the decision. It was submitted that the removal of a Deputy President from office was not an ordinary procedural matter, but constitutional event with profound democratic implications. That Article 118 had to be read together with Articles 1 and 10 of the Constitution, and that sovereign power belonged to the people, and Parliament merely exercised that power in a delegated capacity. When Parliament embarked on a process that might remove from office a deputy president who was directly elected by the people, it was obliged to ensure that the people themselves were accorded a meaningful opportunity to be heard. It was further submitted that in such a context, public participation became a constitutional condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a national elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement, and Articles 10(2)(a) and 190 sub-article 1b of the Constitution mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wambora, that the Constitution did not intend a scenario where an otherwise popular deputy president could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as a constitutional safeguard against the abuse of impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate meaningful public participation, as such short time could not reasonably reach most Kenyans, particularly ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of National Assembly and the National Assembly failed to utilize several well-established participatory mechanisms ordinarily available to them, including ICT platforms for structured public input, county-based citizen engagement forums, public notice boards, and accessible announcements, town hall meetings, engagements through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single venues, diluted constitutional high-level representation, and transformed public hearings into mass gatherings where individualized contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. It was submitted that a process of this gravity required decentralized, not consolidation of engagement forums. On the rigid and non-deliberative format of engagement, they submitted that the National Assembly employed a highly structured and restrictive model of engagement in which parliamentary clerks read out the charges, provided a general explanation of the processes, attendees were given limited time to offer their views, and those views were recorded in a pre-designed format for compilation. That format did not allow robust deliberation, did not permit cross-examination of claims, and did not facilitate informed submissions on the constitutionality or factual basis of the impeachment. It was submitted that public participation had to be interactive and not merely a formalistic exercise. On the inadequacy of the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue or nuanced analysis. This reduced public participation to checkbox voting rather than substantive constitutional engagement. They acknowledged in their submissions that the standard required was not perfection but reasonableness. However, reasonableness is in a matter of this magnitude required the Speaker of the National Assembly and the National Assembly to have actively mobilized public awareness through non-public convergence points such as churches, mosques, temples, public barazas, national radio stations, vernacular broadcasting stations, and other accessible civil forums. The failure to which those avenues significantly restricted the reach of the notice and consequently diminished participation. The process was submitted to have been conducted on an extremely short notice, centralized into 2 venues and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagements, all of which demonstrated a failure to meet constitutional standards and called into question the validity of the impeachment of His Excellency Gachagua. It was further submitted that the removal of a deputy president from office was not merely an internal matter of parliament, but a matter of national constitutional significance affecting the democratic will of the electorate, the integrity of the executive structure, the political stability of the Republic of Kenya, and the sovereignty of the people, and that accordingly the electorate had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Kituo cha Sheria submitted that even where Parliament acted within its constitutional mandate, when it undertook a process that received and evaluated evidence and reached determinations adverse to rights, reputations, and the tenure of office, it was obliged to meet minimum content on procedural fairness. It was submitted that the Senate proceedings bore all the hallmarks of a quasi-judicial trial, from pleadings, evidence, contested facts, and was finding to a grave sanction in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Actions Act 2015 therefore applied with full force. Impeachment of a national executive was not a mere political debate, but a structured constitutional trial with legal standards burdened with reputational, civil, and democratic consequences, which made the rights to be present, to cross-examine, and to be re-examined all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and that scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Maxwell, in which the court confirmed that the right to a fair hearing and right and fair trial ought not to be unduly impeded, and that a trial body had to be circumspect in purporting to limit and take away such crucial rights, since Article 25C specifically provided that there was never to be any derogation from the right to a fair hearing. It was further submitted that while impeachment was sui generis, the logic of adversarial testing of allegations applied with equal, if not greater, and his counsel sought an adjournment, which was refused. The Senate proceeded in absentia without counsel, received and accessed evidence, and removed him from office, thereby extinguishing his ability to be present, to be cross-examined, and to be re-examined, and to participate meaningfully. It was submitted that a fair process entailed reasonable accommodation, including adjournment, where good cause was shown and no prejudice will be suffered that could not be compensated by way of cost or by way of time. Kituo cha Sheria relied on Githiga and 5 others versus Kiruti Factory Company Limited, in which the Supreme Court confirmed that the right to a fair trial indicated that the right to a fair hearing indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been given prior notice of the case against him, a fair opportunity to answer, and the opportunity to present his case. It was submitted that this was precisely what was not accorded to His Excellency Gachagua. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalized party where fairness and due process rights were under Articles 47 and 50 were at stake was unreasonable, disproportionate, and constitutionally infirm. They argued that the right to be heard required a real and effective opportunity to participate, not a mere formality, and included the right to attend and to answer the case one first, as well as the right to correct and contradict the allegations made against one. Further, that an adjournment was a recognized incident of a fair hearing where unavoidable circumstances prevented attendance or effective participation, and accordingly the denial of a reasonable adjournment amounted to a denial of the right to be heard. The Senate could have proceeded in His Excellency Gachagua's absence if his conduct had made it impossible to continue the hearing, or if after due notice his notice was unjustified. In the present case, they submitted that that absence was explained as a medical emergency and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachagua's ability to participate meaningfully was impugned. It was further submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where adverse oral evidence was received and weighed, cross-examination was then crucial for testing credibility, the denial of which hollowed out fairness and tainted the decision. It was submitted that expedition could not cannibalize fairness, and that Articles 10, 47, and 50 demanded reasonable accommodation, especially where a short adjournment would have cured the prejudice occasioned by a medical emergency. Kituo cha Sheria submitted that courts had emphasized committee and institutional respect, and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been insulated from judicial scrutiny where constitutional requirements were breached. Relying on the Mwangaza case, Kituo cha Sheria recalled the court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, ran the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted that constitutional review was therefore available to term procedural impropriety in the exercise of public power, even in political charged arenas. Further reliance on the relying on the Wambora case, Kituo cha Sheria recalled the Court of Appeals statement that the process of removal lay entirely in the County Assembly, wherein it was initiated, and the Senate, wherein it was concluded, but that the court might only come in when necessary to confirm that the process had been properly followed as laid down in the Constitution and the statute. Accordingly, they submitted that the question before the court was not how the Senate should have voted, but whether it had obeyed the Constitution in getting there. It was submitted that Article 10 of the Constitution bound all state organs whenever they applied or interpreted the Constitution or enacted, applied or interpreted any law or made or implemented policy, public policy decisions, and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially in a medical emergency, subverted human dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not asking the court to supervise the National Assembly and the Senate debate or to substitute their judgment, but only to ensure that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2024 by the Senate were procedurally unfair, unconstitutional, and ultra-vires. A declaration that the Senate, acting as a quasi-judicial body, violated Articles 47 and 50 of the Constitution by denying cross-examination, re-examination, and a reasonable adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit directing the de novo hearing before the Senate in strict conformity with constitutional and statutory fair hearing requirements, including presence, representation, examination, disclosure, and reasonable determination, and such other orders as the court may deem fit to vindicate the Constitution and the public interest in a lawful, rational, and fair impeachment process. Kituo cha Sheria concluded its submissions by urging the Constitution that the Constitution erected procedural safeguards precisely because impeachment was a constitutional earthquake, where the Senate refused a short adjournment despite His Excellency Gachagua's hospitalization, proceeded in absentia, and delivered the ultimate sanction without the presence, cross-examination, and re-examination of the accused. The process failed the constitutional test. It was submitted that this court ought to intervene not to rewrite politics, but to enforce procedure, and in so doing, preserve Kenyans' commitment to the rule of law, constitutionality, accountability, and human dignity. We'll now proceed to responses and submissions to the consolidated petitions. We'll start with the second and the seventh respondents' cases. The National Assembly and the clerk to the National Assembly were the second and the seventh respondent in the consolidated petitions. They jointly responded to the petitions through a replying affidavit sworn by its clerk, October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. They asserted that the impeachment process was entirely constitutional, lawful, and procedural fair, and that all actions were taken, all actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the National Assembly standing orders, as well and the court directives. They further posited that the impeachment of the Deputy President followed Article 150, Sub-Article 2 of the Constitution, which applies Articles 144 and 145 of the for the President with necessary modification, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. They deposed that the Speaker validly confirmed that the motion met the required legal form and the signature threshold of at least 117 MPs, or 1/3 of all members. That public participation was adequate, inclusive, and compliant with court orders, as the National Assembly placed advertisements in all three national dailies on the 2nd, 3rd, and 4th of October 2024. Public hearings were held on the 4th of October 2024 across the country, and that public and The public will submit views by way of email, post, hand delivery. A dedicated template in English and Kiswahili was provided, and they were also able to visit the constituency offices. The respondents contended that upon being served with a court order on the 3rd of October 2024, they extended public participation to the constituency level until 5th of October 2025, and that a public participation report was published. They asserted that the process was real and not illusory, that public participation was not part of the Deputy President defense, as it was meant to gather general public views to inform the Assembly, and that holding it first preserved the integrity and the independence of public input, preventing it from being influenced by the Deputy President's defense or parliamentary debate. The respondents maintained that the Deputy President still received his full right to be heard during the debate on the 8th of October 2024, where Honorable Jane Jeremiah closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. Further, they reliably learned that the closure was directed by the woman representative herself, since she was vehemently opposed to the impeachment. The respondents averred that she cannot then benefit from her own actions that obstructed the public participation exercise. The respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote and 282 members voted in support of the impeachment and 44 voted against, which exceeded the required 2/3 majority under Article 145(2) of the Constitution. That on the 9th of October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate of the resolution by transmittal. The respondents denied any constitutional or otherwise wrongdoing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with course. In respect to their submissions, the National Assembly and its clerk's onslaught on the constitutional petition was led by learned counsel, Mr. Eric Gumbo, Mr. Paul Nyamodi, and Honorable Gitonga Murugara. They identify the following issues for this court's determination. A, what is the extent of this court's jurisdiction to hear and determine the constituted petitions relating to the impeachment of His Excellency Gachagua? B, whether the sub judice rule under Standing Orders 89 and 103 of the National Assembly and the Senate Standing Orders bars parliamentary proceedings on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid grounds for challenging the impeachment proceedings conducted before the Senate. E, whether the impeachment unconstitutionally subverted the sovereign will of the electorate expressed in the 2022 general elections, contrary to Articles 1, 2, and 38 of the Constitution. F, whether the nomination, approval, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and clerk submitted that the impeachment of His Excellency Gachagua as Deputy President was constitutionally valid, procedurally proper, and politically necessary to uphold accountability and the rule of law. They also defended the subsequent nomination, approval, and appointment of Honorable Kindiki as Deputy President as fully compliant with the Constitution. Their positions remained that an impeachment is a political process, not a judicial one, and that the Constitution vests sovereign power in the people exercised through their elected members under Article 1, that the Constitution mandates public participation, strict timelines, and bicameral supermajority representation requirements of the 2/3 in both houses, making the impeachment framework rigorous and transparent. They submitted that the comparative analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard against abuse of office. On the High Court's jurisdiction under Article 165 of impeachment proceedings, they submitted that such power is only residual and supervisory, not appellate. That impeachment is a political process entrusted to Parliament, and courts should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual constitutional rights, and citing the cases in Wambora and Sonko. They asserted that the courts must show deference to Parliament in matters where the Constitution grants Parliament discretion. Learned Counsel also cited the decision in the Supreme Court of Philippines in Re Sara Duterte, which similarly held that courts will not encroach on co-equal branches on political questions. It was their further submission that Standing Order 89 of the National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is sub judice only if that the petitioners did not raise any sub judice objection during the parliamentary proceedings, and they cannot raise it now. The National Assembly and clerks admitted that the Constitution itself imposes tight timelines under Article 145, that is 2 days to notify Senate, 7 days to convene a Senate, and 10 days for the committee investigation. They contended that impeachment is urgent as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate excess of parliamentaries' power under Article 124 to regulate its internal affairs, and that timelines is a common case. It was their further submission that public participation was adequate as the National Assembly issued notices in the Kenya Gazette, national newspapers, news website, and social media on the 2nd, 3rd, and 4th October 2024. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order on constituency level participation, and 223,083 citizens submitted views, which they stated was an unprecedented level of civic engagement. Further, that the public views the public views template was provided in English and Swahili. Submissions were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness, not perfection, and that the Supreme Court and Cabinet Secretary for National Treasury and Planning and 4 others were cooperated with the 2 others held that timelines must be considered when assessing public participation adequacy. They submitted that His Excellency Gachagua's response was not required to be circulated, was not required to be circulated simultaneously, as the public role is to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were unsubstantiated, and that isolated incidents do not vitiate an entire process. They also submitted that public participation report was submitted in Parliament and recorded in a Hansard, which is a valid parliamentary record. They stated that the impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these grounds met the threshold set in the Wambora's case of being serious, substantial, weighty, with clear nexus and precise constitutional provisions. That the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that the Deputy President was accorded a fair hearing as he received prior notice of the charges. He filed his written response and appeared in person with counsel, and he was given 2 hours to address the National Assembly. The National Assembly and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 gender principle does not invalidate Parliament, as Articles 97 and 98 of the composition of Parliament have been fully complied with. On the two-thirds general principle under Article 81B, it was submitted that this was an aspirational provision to be achieved progressively, not a condition precedent to Parliament's validity. And that Article 261 provides a mechanism for addressing legislative delays, and that no advice from the Chief Justice or action by the President has occurred to dissolve Parliament. They contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an absurd and constitutionally impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations were unproven, and further that the Deputy Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings. He stated that the test for bias is objective, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. Council added their voice to the position that the Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, Sub-Article 3A, mandates the Senate convene and hear such charges. That Article 145, Sub-Article 3B, uses the word may, and therefore the appointment of a special committee was discretionary and not mandatory. And the semicolon and in Article 145, Sub-Article 3, do not convert the discretionary power into a mandatory obligation. They reiterated that the Senate motion to appoint a special committee on the 9th of October failed, as it was not seconded, and the Senate then properly proceeded in plenary. They relied on the Supreme Court Court and Sonko case that confirmed that for governors, the Senate may proceed in plenary or by the committee, and that the same applies to the Deputy President. It was also the estimation that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the Senate may regulate its own procedures under Article 124, Sub-Article 1, and the 10-day deadline was a reasonable exercise of procedural autonomy to ensure expedition. Council submitted that impeachment must be concluded without undue delay, and the timeline reinforce accountability and good governance. It was their father's position that His Excellency Gachagua received a fair hearing in the Senate, as was represented by Council throughout, was cross-examined at the National Assembly. He cross-examined National Assembly witnesses, and he filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment unreasonably, as senior counsel Moite was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachagua, that no medical evidence of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday 19th, October 2024 within the constitutional time frame, but this motion failed on a vote. The National Assembly and the clerk submitted further that the decision to proceed in absentia did not violate fair hearing, as His Excellency Gachagua had already filed his evidence and opted out after cross-examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocation was not disproportionate, as both parties were accorded equal time. The National Assembly submitted that it also could not call all its witnesses due to time constraints, and that this was a consequence of expedition and not bias. They further submitted that the Senate had no independent duty to conduct public participation, which under Articles 10 and 118 applies primarily to legislative functions. The Senate, when hearing impeachment, acts as a quasi-judicial capacity, not a legislative one, and that public participation occurs at the National Assembly during the initiation stage, not at the Senate at the trial stage. Council submitted that comparative practice in South Africa, USA, and in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory, and that the court in Mwangaza versus Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the county assembly level, and the same applies in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, as a Speaker's role is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish bias, and that the petitioners have not pointed to any specific or act or omission showing a real possibility of bias. They restated that the test for bias is objective and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that there is participation of honorable things in that Article 77(1) restricts gainful employment that is inherently incompatible with state office, and that presenting a part in proceedings is not such an employment. That any alleged illegality would affect the advocates personally and not the validity of the They further submitted that the Senate applied the correct standard of proof for impeachment, which is above the balance of probabilities but below beyond reasonable doubt, as set out with the Supreme Court in the Sonko. The Senate found 5 charges substantiated, including gross constitutional violations, attacks on judicial independence, ethnic incitement, gross misconduct, and that the evidence was substantial and credible, including His Excellency Gachagua's own public admissions. Learned Counsel submitted and urged that the court should not undertake a merit review of the Senate findings. Counsel reiterated that impeachment does not subvert the sovereign will of the people, as it is not an affront to democracy, but an affirmation of accountability. That the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the joint ticket of the President and the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and accountability mechanisms and with distinct accountability mechanisms. Counsel gave comparative analysis of the U.S. Vice President resignations while President Nixon remained, and Brazil's President Rousseff's impeachment. Require removal of the principle. They contended that Article 150 of the applies Article 145 in the certifications, and that this acknowledges distinct offices and not a merger. On the validity of His Excellency Kimbiki's nomination, approval, and appointment, the National Assembly and the clerk submitted that a lawful vacancy arose by operation of law under Article 145(7), as the impeachment was valid. They stated that IBC clearance was not constitutionally required for a deputy president nomination under Article 149, and that the president merely sought information of the voter registration status and MP qualifications from IBC as a matter of prudence. Counsel submitted that IBC Secretariat acted within administrative mandate by providing information which is not commission-led constitutional function. Counsel referred this court to the Supreme Court advisory opinion in IBC versus AG 2025, where it drew a distinction between commission-led functions such as boundary delimitation and secretariat administrative functions, including the day-to-day operations. They submitted that providing information falls within the latter. It was their submission that His Excellency Kindiki met constitutional qualifications for appointment as is a Kenyan citizen by birth, qualified to be an MP and nominated by a political party, UDA, thus satisfying Article 137 as read with Article 148, and that his party membership was properly documented with the register of political parties. They contended that allegations of misconduct during His Excellency Kindiki's tenure as Cabinet Secretary were mere allegations, and that no judicial or quasi-judicial finding of culpability exists, and that the court in International Center for Policy and Conflict and 5 others versus AG, reported 2013, held that unproven allegations cannot disqualify a candidate. That holding a cabinet secretary position did not disqualify him under Article 77, as this provision prohibits gainful employment that creates a conflict of interest, but does not bar a state officer from seeking elective office. Council submitted that disqualification for holding state office is governed by Article 137, sub-Article 2B, that requires resignation 6 months before a general election. But it is not applicable to a mid-term vacancy, which process under Article 149 is sui generis. The National Assembly submitted that the voting process complied with Article 149(1), which requires the National Assembly to vote on the nomination, which is an electoral determination by plenary, not an approval process requiring committee. Process of deputy president, public appointments and public parliamentary approval act, and the Standing Order 45.3 do not apply to this sui generis constitutional process, and that the Supreme Court entrusted a Society for Human Rights Alliance versus Matemo and 3 others held that where the Constitution provides a specific procedure, statute cannot add to or amend it. It was also their position that no public participation was required for the nomination under Article, as Article 149, sub-Article 1, does not prescribe public participation, and that the nomination and approval is an executive-led elective process, not legislative business, under Article 118. That it would be incongruous to require more process for a mid-term vacancy than a general election, where the ticket is approved by popular vote without prior public hearings. For the aforementioned reasons, the National Assembly and the clerk urged the court to dismiss all relief sought in with the council submitting that no constitutional violations had been proved. The impeachment was constitutionally regular and substantively justified. Damages are not automatic, as no breach had been established, and awarding damages will punish Parliament for performing its constitutional duty. That pension and retirement benefits are for honorable retirement, not for removal by impeachment, and that quashing the resolution and nullifying His Excellency Kindiki's appointment will create a leadership vacuum and constitutional chaos. Council thus urged this court to dismiss the constitutional petitions with cost to them, find that the impeachment of His Excellency Gachagua was lawful, constitutional and constitutionally proper, and that the nomination, approval, and appointment of His Excellency Kindiki as Deputy President was valid and constitutional, and that the court should decline to grant any of the relief sought by the petitioners. On the third and fourth respondents' cases, the Speaker of the Senate and the Senate, who are the third and fourth respondents respectively, challenged the consolidated petitions through the affidavit sworn by Jeremiah Nyegenye, who is the clerk of the Senate and secretary to the Parliamentary Service Commission. The affidavit was deposed on the 21st of October 2024. From the outset, it was their case that under Articles 93(1), 96, sub-Article 4, and 145 and 150 of the Constitution, the Senate is mandated by with the role of considering the impeachment of a deputy president. They asserted that process is guided by the National Assembly's Standing Order 64 and 5, which dictates the procedure for introducing and supporting an impeachment motion. To that end, it was that on the 1st of October 2024, Honorable Mutuse introduced a motion in the National Assembly seeking the removal of His Excellency Gachagua on the basis of 11 grounds. 11 grounds, including gross violations of the Constitution, undermining, devolution, attacking independence of judges, committing economic crimes, and publicly subordinating the president. It was their position that the National Assembly conducted extensive public participation from 2nd to 5th of October 2024 and formally approved the motion on the 8th of October 2024. Following the approval, the Speaker of the National Assembly notified the Speaker of the Senate of the resolution in a letter received on the 9th of October 2024, which included the motion, electronic evidence, relevant Hansard reports, public participation, advertisement and reports, and court orders. He asserted that the Senate Speaker convened a sitting on the 9th of October 2024 through Gazette Notice number 13170, during which a motion to establish a special committee to investigate the matter was defeated. As such, the proceedings had to be held in plenary, and it was deposed that the Speaker designated 16th and 17th of October 2024 for the plenary hearings formalized in Gazette Notice number 13178. Speaking to the fairness in the process, the clerk deposed that on the 9th of October 2024, the Senate served an invitation to His Excellency Gachagua and the National Assembly to appear to submit witness details and evidence. It was the case that on the 14th of October 2024, His Excellency Gachagua indicated his presentation by Mrs. Swanya and company advocates and filed his response to the allegations alongside supporting evidence. They stated that the plenary hearings commenced on the 16th and 17th October 2024, and after the National Assembly concluded its case on the 17th of October 2024 at 1:15 p.m. His Excellency Gachagua, lead counsel Mr. Paul Muite, senior counsel, informed the Senate at 2:30 p.m. that his client was missing and had been taken ill. It was pointed out that after suspending the proceedings until 5 p.m., counsel requested an adjournment to 22nd October. He stated that a substantive, subsequent procedural motion to sit on Saturday, 19 October 2024, to meet the constitutional deadlines was defeated, prompting His Excellency Gachagua's counsel to exit the proceeding. Gachagua's counsel failed to provide cogent material evidence of his illness. As regards the constitutional timelines, it was their case that impeachment could not be posed without violating the Constitution. They refuted the claim that the trial occurred in absentia since His Excellency Gachagua had actively participated through his advocate's opening statements, cross-examination, and the National Assembly's witness and filing of the respective witness affidavits. In challenging the claim that the public participation was not conducted, the Senate and the Speaker stated that an order of the High Court in Kerugoya did not mandate the Senate to conduct public participation, as the Senate functions exclusively as a trial chamber akin to a court. In conclusion, it was disposed that the Senate voted on the impeachment charges, where 5 charges comprising ground 1 on gross violation of the Constitution, ground 4 on undermining the independence of judges, ground 5 fidelity to the oath of office, ground 6 on crimes under national cohesion, and ground 9 on gross misconduct and ground 9 on gross misconduct concerning NAS were substantiated by the required majority. The clerk deposed that the Senate resolved to impeach His Excellency Gachagua, a decision officially gazetted on 17th of October through Gazette Notice number 13400. On the foregoing, this court was urged to find that the impeachment power is inherently political and vests solely in Parliament, which triggered the political question doctrine, thereby inviting this court to exercise judicial restraint Ultimately, the Speaker of the Senate and the Senate prayed that the petitions be dismissed with cause. The third and fourth respondents filed submissions dated for the 24th of April 2026, and they were highlighted by their legal team led by Professor Tom of Gender Senior Counsel, Mr. Edwin Mukele, Ms. Mercy Thanji, Ms. Opola, and Honorable Hilary Sigei. They maintained that the entire impeachment process meticulously complied with all constitutional timelines, including standing orders and the principles of natural justice. On the question whether His Excellency Gachagua was accorded a fair and reasonable opportunity to be heard, they submitted that the hearing aligned with the due process and the Audi Alteram Partem rule to define the threshold of a fair trial. They relied on the Black's Law Dictionary 7th edition at page number 725 and the Halsbury's Laws of England 5th edition 2010 volume 61 at paragraph 639. The dictionary defines the right to be heard as follows, and they quote, the rule that no person is to be condemned unless that person has been given prior notice of the allegations against him and a fair opportunity to be heard is a fundamental principle of justice. This rule has been refined and adapted to govern the proceedings of bodies other than judicial tribunals, and a duty to act in conformity with the rule has been imposed by the common law on administrative bodies not required by statute or contract to conduct themselves in a manner analogous to a court. End of court. To bolster their case, the Senate and the Speaker referred to the President in Evans, Kidero and 4 others, was Ted Ndungu Waititu and 4 others, 2014 Supreme Court decision, which approved the Supreme Court of India's decisions in Indru Ramchand, confirming that a fair hearing possesses 2 elements, namely the opportunity must be given and it must be reasonable. Council drew further support from the Uganda Supreme Court in Obiga versus Electoral Commission and another, and in Saulo Kandie versus James Kwambai Cheruyot, which is a Court of Appeal decision, to illustrate that the right to be heard is fulfilled when a party is supplied with the opposing evidence and given a full venue to present their case, comment, or call witnesses. As regards the sufficiency of written evidence and constructive waiver, they stated that His Excellency Gachagua fully participated in the initial phases of the trial by filing comprehensive responses, witness statements, and documentary or video exhibits, which legally constituted his defense in chief under Rule 6 of the second schedule to the Senate standing orders. They submitted that an oral hearing is not an absolute prerequisite for natural justice, and they fortified their position through the decision in Economic Freedom Fighters and 3 others was a Speaker of National Assembly. This is a South African case, and the Kenya Revenue Authority and Menginya versus Menginya Salim Magara's case. They also relate to Swalwarjan versus Race Relations Board Limited. This is a foreign case, as well as R versus Immigration Appeal Tribunal. They also referred to the case of Jacob Ochanda versus Kenya Hospital Association Limited, to demonstrate that a hearing can be fairly conducted through written representations. The Speaker and the Senate faulted His Excellency Gachagua, stating that because he chose to walk out of the proceedings after the Senate had voted down an adjournment, it was deliberate boycott. They implored the court to find that voluntary absence constituted a constructive waiver of the right to be heard orally. Support to that end was drawn from various authorities, among them Regina versus Jones, R versus Governor of Brixton Prison, and the Ghanaian Supreme Court case in the Republic versus High Court of Accra. They affirmed that The Senate acted within its lawful discretion when it denied His Excellency Gachagua's request to adjourn the proceedings due to his sudden hospitalization. In reference to the decision of the Supreme Court in Sonko and the Mate, the Senate and the Speaker emphasized that courts must be slow to interfere with the internal affairs and the procedural discretion of Parliament. Further support was drawn from the decision of the Supreme Court in the famous cycle agencies case and for others versus Masukulal, Ramji Kuria, where it was observed that an adjournment requires sufficient cause based on proper materials. They argued that without formal medical proof of total incapacitation, the Senate was not required to stop its proceedings. To further credence to the foregoing position, they found support from the decision in Serem versus Republic, Court of Appeal decision, and Okaka and another versus Odundo, High Court decision, and it was their case that the strict approach was dictated by the mandatory 14-day timeline to dispose of special motions under Senate Standing Order number 74-2A. On the question whether investigation of charges met the requisite standard of proof, the Senate asserted that it thoroughly investigated and voted on each individual charge according to the established intermediate standard of proof, which is above a balance of probability but below reasonable doubt threshold. It was their case that the standard was set by the Supreme Court in the Sonko case, which declared that proving even a single charge is legally sufficient to sustain an impeachment. Consequently, they submitted that the court must decline to reevaluate the evidence or substitute its own finding for the political question decided by the Senate under Article 96, Sub-Article 4 and Article 145, Sub-Article 3 of the Constitution. On the question challenging His Excellency Gachagua's claim that the Senate acted unprocedurally by failing to form an 11-member special committee under Article 143, Sub-Article 3B, the Speaker and the Senate submitted that the word may in the Constitution and Rule 2 of Part 1 of the second schedule to the Senate standing orders grant the Senate absolute discretion to choose between a committee or full plenary. They submitted that such interpretation is anchored in the Supreme Court case in the matter of the Speaker of Senate rendering or referencing the matter of interim independent electoral commission and the Court of Appeal decision of Cooperative Bank of Kenya Limited and they contrasted Article 135 Sub-Article 3B with Article 152 Sub-Article 7 of the Constitution, which uses the mandatory phrase shall appoint when dealing with the dismissal of Cabinet Secretary. It was the case that since a motion to form a special committee was moved but failed to be seconded under Standing Order 70, the Senate properly proceeded in plenary, meticulously satisfying the oversight parameters affirmed in the by the Supreme Court decision in the Swecho case. As regards the contentious issue of public participation, they contended that there was no legal basis for the Senate for a secondary round of public participation because the National Assembly had already completed a rigorous national public participation drive between the 2nd and the 5th of October 2024 through extensive media notices and public feedback templates. They submitted that to demand a repetitive exercise from the Senate would be an imprudent waste of state resources. Separately, the Speaker and the Senate submitted that during an impeachment trial under Article 145 3A, the Senate acts exclusively as a quasi-judicial body, evaluating specific charges rather than performing a standard legislative function, exempting it from public participation requirements of Article 10 and 118. They dismissed the argument that Parliament was illegally constituted due to a threshold failure to implement the two-thirds gender rule. They further submitted that although the former Chief Justice David Maraga issued a dissolution advisory to the 4th President, the 12th Parliament dissolved by operation of law and the 13th Parliament was lawfully established following the general election of the 9th August 2022, seeking to rely on Article 261, Article 5 running to 7. The Senate and the Speaker submitted that the ground that the gender rule mechanism is intended to compel future compliance and not to retroactively invalidate state operations. They warned that declaring Parliament unlawful would cause an absurd constitutional crisis, invalidating national budgets, legislation, and public appointments, which violates the governance promotion mandate of Article 250, as the gender issue is actively pending before a five-judge bench in Coachella and others as the Chief Justice and President of the Supreme Court of Kenya and others. The Speaker and the Senate rejected the allegation that the Senate was mandated to conduct a full hearing for filling the subsequent vacancy of the office of the Deputy President. They pointed out that Article 149, Sub-Article 1 of the Constitution, expressly grants the exclusive mandate to vote on and approve a nominated Deputy President to the National Assembly, entirely omitting the Senate. It was their case that by applying the statutory construction principle established in the case of the Federation of Women Lawyers Kenya, FIDA versus AG, the initiative of strategic litigation in Africa, statutes could be interpreted to override the explicit statutes could not be interpreted to override the explicit text of the Constitution. On the strength of the foregoing submissions, the Speaker and the Senate urged the court to dismiss all the consolidated petitions with costs.
I will take over from the 5th respondent's case. The Attorney General, that is the 5th respondent, challenged the petitions through grounds of opposition dated the 7th of November 2024. She argued that the court should not elevate Parliament's factual assessments, since its role is strictly to ensure that reasonable inferences were drawn from the available evidence. It was her case that the removal proceedings against H.E. Gachagua were purely legislative, neither entirely administrative nor judicial, and therefore were not subject to standard administrative or judicial review as suggested under Article 47(3)(a) of the Constitution. Further, the Attorney General asserted that the court could not substitute the legislature's discretionary decision with its own, as doing so would constitute a usurpation of the constitutional functions of an independent branch of government. She maintained that the proceedings before the legislature were lawful, efficient, procedure successfully balanced the need to protect H.E. Gachagua's constitutional rights, safeguard the process from abuse, and prevented unnecessary disruptions to public administration. Regarding public participation, the AG clarified that the Constitution did not permit members of the public to vote on an impeachment motion, as that discretion was expressly reserved for legislators who constitutionally represent the sovereign will of the people. It was explained that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings and the ultimate decision. It described the consolidated petitions as disguised appeals regarding the merits of Parliament's decision and argued that the judiciary lacked an appellate mandate over the impeachment of a deputy president, since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, and it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the outcome, that the transition process was conducted within constitutional timelines by the proper constitutional repositories, and that the consolidated petitions lacked merit. The fifth respondent submissions are dated 4th March 2026. They were orally highlighted by a team of counsel led by Professor Gidu Muigai, Senior Counsel, alongside the Solicitor General, Mr. Shadrach Mose, Mr. Emmanuel Bita, now a judge of the High Court, and Mr. Charles Mutinda. The Attorney General submitted that accountable governance was a core part of the Constitution, which established removal from office through impeachment as one of the tools of governance amongst the many avenues of exercising oversight and facilitating accountability. He relied on the Supreme Court decision in Swecho, where the Apex Court stated that its purpose was to ensure intent general submission that the removal proceedings for a deputy president were textually committed by the Constitution to the National Assembly and Senate, and that both institutions were vested with exclusive power to remove the deputy president, subject only to procedural requirements set out in the Constitution and in the standing orders. That both houses were free to determine the procedures for receiving and considering the evidence necessary to discharge their duty to conduct impeachment hearing. With regard to the constitutional basis for impeachment, the Attorney General cited Articles 150, 144, and 145 of the Constitution, which she submitted established a sequential two-stage process. In the first stage, a member of the National Assembly initiated the process by filing a notice of motions supported by at least a third of all the members, which motion, if passed by at least 2/3 of all the members, was then transmitted to the Senate for substantive hearing. On the substance of the charges, the Attorney General submitted that the charges against H.E. Gachagua were substantiated to the prescribed standard to warrant his impeachment. She identified the specific charges upon which H.E. Gachagua was found culpable. On the standard of proof applicable to impeachment proceedings, the Attorney General relied on Sonko and the Court of Appeal decision in Wambora, both of which we have already referred to, which had held that the standard was above a balance of probability but below reasonable doubt, and that the allegations must be serious, substantial, and weighty, and must disclose with a degree of precision the constitutional provisions alleged to have been grossly violated. The Attorney General submitted that this court should not sit on appeal over Parliament's evaluation of facts and should not substantiate the discretion of the members of the legislature with its own. The Attorney General further relied on the advisory opinions of the Supreme Court in the Speaker of Senate and another, as well as the matter of the IEBC 2011 Supreme Court decision for the proposition that governmental powers were distributed among different organs, each exercising distinct functions under the Constitution, and that courts were required to respect the institutional mandate of Parliament. The doctrine of presumption of regularity was equally invoked, encapsulated the doctrine of presumption of regularity, and it was submitted that government action enjoyed a presumption of legality and that the burden lay on the challengers to demonstrate unlawfulness. The Attorney General relied on the Supreme Court's decision in Odinga and another versus REBC, our court and another, as well as, sorry, it's the same decision, Odinga and another versus the IEBC, including our court and another, the Attorney General and another as interested parties and amicus. On a comparative method, comparative jurisprudence, the Attorney General submitted that both the United States and the Philippines recognize the political nature of impeachment proceedings, and the power is vested in the legislature, thereby warranting judicial deference to the merits of legislative decisions. The Attorney General relied on the case of Nixon versus the United States, where the United States Supreme Court held that challenges to Senate impeachment procedures were non-justiciable under the political question doctrine, as well as the Kitet decision that we have already cited. On the part of the petitions relating to the nomination and approval of H.E. Kindiki, the Attorney General submitted that the provisions of Article 149 envisaged a sui generis procedure for the nomination and assumption into office of a deputy president. It was the Attorney General's submission that the process under Article 149(1) was neither an election in the traditional sense nor an appointment, as the text of the Constitution employed neither of those terms. In support of the sui generis nature of the process, the Attorney General drew on comparative constitutional provisions from the USA, Ghana, and Nigeria, each of which provided for a distinct mechanism of filling a vacancy in the office of Vice President through presidential nomination and legislative confirmation. The Attorney General submitted that as H.E. Kindiki was nominated by the President within 14 days after the vacancy arose, and the National Assembly voted on the nomination within 60 days, there had been no infringement of either the text or the spirit of the Constitution. Moving to the ninth respondent's case, the Honorable Mutuse responded to the consolidated petitions through a replying affidavit sworn on 22nd October 2024. He deposed that on 1st October 2024, pursuant to Article 150B, read with 145 of the Constitution and the Standing Order 64 and 65, he gave a notice of a special motion for the removal from office by impeachment of H.E. Gachagua. He was aware that the special motion was a time-bound exercise pursuant to the Standing Order 64.2 and 65, which required that it be disposed of within 7 days of the notice being given, failure to which it would be deemed as withdrawn. Honorable Mutuse averred that while Articles 145 and 150 of the Constitution and Standing Orders did not expressly require public participation in a special motion, Article 118(1)B of the Constitution imposed on the Speaker of Parliament the obligation to facilitate public participation in legislative and other business of Parliament and its committees. He deposed that it was in that spirit that the National Assembly, with a view to facilitate public participation, invited members of the public to submit their views, and public hearings were thereby conducted across all the 290 constituencies on 4th October 2024. A notice dated 4th October 2024 by the Clerk of the National Assembly extended the period of public participation to 5th October 2024. Honorable Mutuse confirmed that on 8th October 2024, Honorable Millie Odhiambo MP tabled a public participation report before the National Assembly. Honorable Mutuse further deposed that on the 3rd of October 2024, the High Court sitting in Kerugoya issued orders directing the National Assembly to organize, facilitate, and conduct further public participation at the constituency level, and that the National Assembly comply with those orders by extending the exercise to the 5th of October 2024. Honorable Mutuse stated that following the tabling of the public participation report, the members of the National Assembly debated a special motion, and that H.E. Gachagua appeared in person for the hearing. After debating and hearing both parties, the members of the National Assembly met the threshold set under Article 145(2) by passing and approving all 11 grounds of the special motion. Honorable Mutuse affirmed that the entire December 2024, the National Assembly to the Senate's resolution had fully complied with all legal procedure provided in the Constitution and relevant laws. Honorable Mutuse emphasized that this court had a judicial and not a political mandate, and that its function was to certify whether all procedural provisions of law had complied with constitutional principles, which was a judicial function. He averred that the issues raised by the petitions raised a political question, a principle of law that referred to cases that courts could not resolve because they involved questions about the judgment of actors in the executive or legislative branches and not the authority of those actors. Honorable Mutuse also cited the position taken by courts in Paraguay, India, Lithuania, and the Philippines to demonstrate that jurisdiction practicing a presidential system of government had been appreciative of the political question doctrine in impeachment matters. He tabulated comparative examples of impeachment proceedings of USA presidents to show that in those jurisdictions the fate of impeachment was left to political devices as opposed to judicial determination. Honorable Mutuse further deposed that under Article 94(2) of the Constitution, the National Assembly and Senate manifested the diversity of the nation and represented the will of the people and exercised their sovereignty. In conclusion, he urged the court to appreciate the prudential standing principle of self-restraint as a jurisdictional limitation on its power and pray that the petitions be dismissed. Honorable Mutuse filed written submissions. Those were dated the 15th of February 2026 and were supplemented on 5th of May 2026. They were anchored on two issues: whether H.E. Gachagua was validly impeached, and secondly, whether the impeachment process was procedural. He submitted that H.E. Gachagua was impeached on grounds on various grounds under the Constitution, violation of national laws, and gross misconduct arising from his conduct. It was Honorable Mutuse's submission that the question for the court was not the political wisdom of impeachment, but whether the grounds for removal had met the constitutional threshold under Article 145(1). Honorable Mutuse further reiterated his position that public participation was not expressly required under Article 145 and 150 or the standing orders, and relied on the case of BAT, submitting that even if there were allegations of lack of public participation, the same would not automatically vitiate the process. He further submitted that the petitioner's demand for public participation in the Senate was legally untenable, as the Senate acted as a quasi-judicial forum during impeachment processes. He submitted that the duty of Senate was to ensure a fair hearing for the accused, not to solicit public opinion on the charges. Honorable Mutuse further relied on the mandatory constitutional timelines governing impeachment proceedings and relied on the Supreme Court's decision in Mate, which held that constitutionally prescribed timelines were of mandatory character and binding on governance processes. In his supplementary submissions, he expounded on the six-part Baker test to Kenya's constitutional framework, on the first formulation, on textual commitment to a coordinate political department. He submitted that Article 150 expressly delegated impeachment to the National Assembly and Senate, satisfying the first condition. He relied on the Supreme Court statement in Swecho that where the Constitution required Parliament to determine a matter in the first place, the courts would be slow to interfere. In the second formulation, on the lack of judicially discoverable and manageable standards, he submitted that Article 145(7) envisaged the finality of the Senate's determination with no provision for judicial appeal or standard or review. On the third formulation, on the impossibility of deciding without an initial policy determination, he submitted that assessments of gross misconduct incompatible with the high calling and dignified status of the office and serious reasons to believe crimes had been committed were inherently political and policy-laden beyond the competence of courts. On the fourth formulation, on the impossibility of independent resolution without expressing lack of respect for coordinate branches, Honorable Mutuse submitted that a merit review of the Senate's determination would substitute the court's judgment for that of elected representatives, constituting a profound expression of disrespect for a coordinate branch. On the fifth formulation, that is the unusual need for adherence to political decision already made, Honorable Mutuse submitted that the vacancy created by the Senate's resolution had already been filled through the nomination, approval, and swearing-in of His Excellency Kindiki as Deputy President. He submitted that to reopen the impeachment question at that stage would create constitutional chaos, cast doubt on the legitimacy of the current office holder, undermine executive suitability, expose the political life of the country to prolonged chaos, as cautioned in Nixon. On the sixth formulation, on the potentiality of embarrassment from multifarious pronouncements, Honorable Mutuse submitted that if the court entertained a merit review and reached a different conclusion from the Senate, conflicting pronouncements from different arms of government would undermine political, rather public confidence in all institutions and weaken the constitutional order. Honorable Mutuse therefore urged the court to appreciate the prudential principle of judicial self-restraint as a jurisdictional limitation on its power to hear and determine consolidated petitions on the basis that they raised a purely political question whose determination would be tantamount to subverting the will of the Kenyan people. He accordingly prayed that the consolidated petitions be dismissed with costs. The 10th respondent's case. The 10th respondent was the United Democratic Alliance, UDA, who challenged the petitions through grounds of opposition dated 6 October 2025. UDA claimed that the petition is untenable since it irregularly and craftily sought to convert political grievances into constitutional disputes, contrary to the Supreme Court's decision in Swecho. Pursuant to the Supreme Court's advisory opinion in Speaker of the Senate versus the Attorney General, UDA urged this court to exercise restraint and avoid interfering with the proceedings of Parliament, except in the clearest cases of constitutional violations. The 10th respondent filed written submissions dated the 24th of August 2026, which were highlighted by Counsel Dr. Adrian Morgan. On the procedure for impeachment, UDA submitted that Article 151 provided for the grounds of impeachment of a deputy president being gross violation of a provision in the Constitution or any other law, serious reasons to believe that the deputy president had committed a crime under national or international law or gross misconduct. It's admitted that Article 152 applied the provisions of 144 and 145 with necessary modifications to the removal of the deputy president. The UDA submitted that having been accorded a right to be heard both at the National Assembly as well as the Senate stage and to be represented in the proceedings, His Excellency Gachagua was found culpable of publicly attacking and undermining the work of the NIS and its officials, undermining the institutional, functional, and decisional independence of judges, and persistently making inflammatory, reckless, and insightful public utterances threatening to discriminate against and exclude sections of the people of Kenya from public service appointments and allocation of public resources amounting to gross violation of the Constitution. It was submitted that the charges were proven to the requisite standard and that the procedure of impeachment under Article 145, 1 and 2 of the Constitution, as well as the applicable standing orders, was followed to the required standards. On the nomination and approval of H.E. Kindiki, UDA submitted that Article 149(1) of the Constitution required the President to nominate a person within 14 days of a vacancy arising and the National Assembly to vote on the nomination. It was submitted the article did not contemplate an appointment, approval of an appointment, nomination by a political party, or the holding of an election as erroneously alleged by the petitioners. UDA submitted that His Excellency Kindiki was nominated within the 14-day period. The National Assembly voted in support of the nomination on 18th October, which was within the 60-day period, and the Speaker of the National Assembly published the resolution via Gazette Notice 13401. It was submitted that the nomination, approval, and swearing in of His Excellency Kindiki were all done in accordance with the law and without any violation of Article 149 of the Constitution. UDA concluded by submitting that the people of Kenya, through their duly elected representatives in the National Assembly and the Senate, have impeached His Excellency Gachagua in order to safeguard integrity in leadership in accordance with the Constitution, the National Assembly and Senate standing orders, and all applicable laws. It was submitted that the decision to impeach His Excellency Gachagua reflected the will of the people of Kenya, which the court should uphold, and that the consolidated petitions were without merit and ought to be dismissed. I look at the 16th respondent's case. That was the IEBC. Responded to the consolidated petitions through the replying affidavit of Marjan Hussein Marjan, the then Chief and Commission Secretary, deposed to on the 25th of October 2024. IEBC refuted the petitioner's claims that it was legally incapacitated. Deposed on the 25th of October 2024. Its case primarily addressed two distinct legal issues raised by the petitioners, namely the constitutional validity and capability of IEBC as currently constituted, and the purported role of the IEBC in clearing or approving a deputy president appointed under Article 149 of the Constitution. IEBC refuted the petitioner's claims that it was legally incapacitated due to the vacancies of the commissioners and that it is an independent commission with perpetual existence established under Articles 88, 251 and 253 of the Constitution, as read with Section 13 of the IEBC Act. Specifically, it relied on Section 7.3 of the IEBC Act, which states that the IEBC shall be properly constituted, notwithstanding any vacancy in its membership. It was its deposition that Sections 11A and 11.2 of the IEBC Act structurally divide IEBC into commissioners who are responsible for policy and strategy, and a fully staffed secretariat which is responsible for day-to-day administration and implementation. It was further its deposition that under Articles 145 and 150, the Constitution dictated the actors, the timelines, the procedures involved, which exclusively empower the legislature and exclude the IEBC. Similarly, it was the IEBC position that Article 149(1) of the Constitution mandates the President to nominate a replacement Deputy President within 14 days of a vacancy for parliamentary approval. Flowing from the foregoing, the IEBC then deposed that the omission of the IEBC in the process signified that the framers of the Constitution did not intend for an electoral body to validate executive midterm appointments. Finally, the IEBC addressed the petitioners' flawed reliance on Sections 99 and 137 of the Constitution. It clarified that the articles relate strictly and unequivocally to the qualifications of individuals seeking election as a member of Parliament or President, respectively. The IEBC claimed that because a midterm vacancy under Article 145 and 150 trigger a nomination rather than a by-election, the clearance protocols under Articles 99 and 137 were not activated. The IEBC stated that while the IEBC maintains the voter register under Article 88(4)(a) of the Constitution and the IEBC Act, and provides public information as required by Section 35 of the Constitution and the Access to Information Act, it is not mandated to vet a nominee's educational, moral, or criminal background, as those duties belong to other state agencies like the EACC and the DCI, and as such, IEBC urged the court to dismiss the consolidated petitions. The IEBC filed submissions dated 27 October 2024, reiterating the deposition of Marjan Hussein Marjan. It was its case that it has no constitutional or statutory role in filling a vacancy in the office of the Deputy President. It maintained the position that Article 149 is a self-executing mechanism requiring only a presidential nomination and parliamentary approval with no mandate for elections, referenda, or IEBC intervention. To that end, it relied on the Supreme Court's decision in Attorney General versus two others versus D and 79 others, which is a Supreme Court decision which established that constitutional and statutory bodies must operate strictly within the four corners of their mandate and cannot extend their powers through implication or interpretive craft. It submitted that compelling it to